Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today's the day I earned that subscription. Today is May the 25th of 2023, and we are here with your legal news roundup. All the legal news occurring in your world so that you can be better legally informed. Our story today deals with an ongoing lawsuit from the parents of Gabby Petito against the parents of Brian Laundrie. You will recall this case as one of those missing girl cases that got national attention. Where is Gabby Petito? Well, as it turned out, Gabby Petito was killed by Brian Laundrie. And then Brian Laundrie ended himself, which is, of course, a tragedy all the way around. Gabby Petito's parents have been suing Brian Laundrie's parents, ostensibly because Brian Laundrie's parents, through their attorney, made some statements that seem to, at least to Gabby Petito's mind, raise the issue of intentional infliction of emotional distress, which is a bit of a disfavored tort because it conflicts with the idea of freedom of speech. But there is a point to be made, right? If you purposefully, intentionally say things that are beyond the pale, designed in a way to inflict pain on a person so they will undergo emotional harm, then if you're engaging in what you might just call cruelty, then that is actionable. So there is a line to be had in this. The tort is, of course, well recognized but somewhat disfavored. And this lawsuit has gone on and have been allowed to proceed, even though, in my best legal judgment, I don't think this qualifies as a matter of intentional infliction of emotional distress as a matter of law. That, of course, is not to say that Brian Laundrie didn't do bad and horrible things. He certainly did. But whether or not his parents bear any responsibility legally is, of course, a different issue. And I have been critical of the judge's rulings thus far. Well, the lawsuit has progressed despite my best legal judgment. And now, as a result of the discovery process as part of this lawsuit, the parents of Gabby Petito have gotten a letter that implicates the parents of Brian Laundrie in the criminal action. So let's learn a little bit more about what is going on. Gabby Petito's parents now have a copy of a letter Brian Laundrie's mother wrote to her son, which includes references to getting a shovel and burying a body. The actual letter itself has not so far been made public, but it appears to contain statements that suggest the possibility that the parents of Brian Laundrie, specifically the mother, has engaged in actions that might be obstruction of justice or might be a conspiracy to dispose of a corpse in an improper way, or even post-action accessory to murder. You know, if you help someone hide the body, that might even be accessory to murder after the fact. So this letter is implicating Brian Laundrie's mother in actions that could very well be criminal. And we've obtained it as part of this discovery process, which might now allow the government to use this letter to potentially prosecute. So that is an interesting development. Attorneys for both sides argued in the courtroom Wednesday over whether the letter is relevant to the lawsuit, which I don't think it is relevant to the lawsuit. The cause of action is intentional infliction of emotional distress. We are concerned, or we're suing over the words that Brian Laundrie's parents used. The words they used, the actions they took, were designed to and created an unfair, unjustified, outrageous taxing on the mind. It was cruel for the sake of cruelty. So this letter, which appears to potentially implicate them in potential some sort of criminal conspiracy, really doesn't speak to the issue that's in this lawsuit. So I would say no, it is not relevant to the immediate cause of action. It might be relevant to some other cause of action. For example, the criminal liability I've been talking about for some time now, but it really doesn't do anything to seem to inform whether or not the statements that they made through their lawyer were of this kind of cruel nature. So I'd say no, it's not relevant. The envelope contained a letter which is undated that says burn after reading and was recovered with the backpack when his remains were found. So, you know, it was on Brian Laundrie's possession. Okay. As we all know, the letter references burying a body, bringing a shuttle, and burying a body, the family attorney said. These are criminal acts, by the way, that the mother said that she would commit. They can very well be criminal and strongly suggestive of criminal. They're suggestive of obstruction of justice. They're obstruction of conspiracy to improperly dispose of a corpse. They're suggestive of accessory after the fact in murder. So yeah, these are pretty serious potential charges that could be laid as it relates to some sort of criminal liability. Not clear how it relates to the immediate cause of action, though. Oh, it's been made public this morning? Oh, excellent. Maybe we'll read it then. I'll just amend out the part where I said it's not clear if it'll be made public, and we'll read it. We'll read the letter. That's fine. We can do that. Thank you for bringing it to my attention. The Petitas sued the Laundrie for emotional distress in connection with the death, intentional infliction of emotional distress. By our words and by our actions, we have designed to create upon you an emotional burden. We have designed to torture you. We have designed to cause you emotional harm. We are acting with the intent to cause you emotional distress. It is a rare tort, but certainly one that is allowed for, because while we allow freedom of speech, we don't allow people to purposefully torture other people with their words, because that would be kind of dumb. So that's how that balance works out. Gabby Petito's remains were found in Wyoming in September 2021, and her death was ruled homicide by strangulation. Brian Laundrie wrote in a notebook that he was responsible for the death. His remains were found the next month in a preserve not far from his parents' home in Florida. Yeah, things were not looking really great for Brian Laundrie there. So I think he saw that the end was nigh and decided to shortchange his way out of the whole thing. A very, very tragic tale all the way around, and sort of what caused this and why it happened and all the rest of it. But the Laundrie's responsibility for this has been tenuous at best. This letter strongly suggests criminal liability. The way that we're able to bring this into light, though, is a little bit problematic, because we're using a mechanism that isn't really designed for this, which potentially might bring charges on them. So I have my legal doubts as to the solidity of how we came into this information. But now that we have this information, what the police will do with it, who knows? Because, of course, there is no statute of limitations when it comes to murder. So if we're going to charge them with accessory, now would be fine, for example. The parents fought to not turn over the letter, arguing it's not relevant to the civil lawsuit. I would tend to agree. I also think the entire civil lawsuit is not legally cognizable. The judge obviously disagrees with me. We have a difference of opinion. That's okay. Sometimes lawyers disagree with each other, even sharply. So I think the judge in this case is just wrong. I think they're wrong. And, that's what I think. But the judge disagrees with me. I'm not the judge. You know what a court of appeals might do with this someday? Who knows? Maybe a court of appeals will eventually agree with me. But by then, of course, maybe it's too late. So we'll see how that progresses. In an affidavit filed before the hearing, a mom over here wrote she didn't know the exact date of the letter, but wrote it with the hopes it would help repair her relationship with her son. Well, get a shovel and bury the body. What is it that a real friend helps you, a friend helps you move, but a real friend helps you move a body? So she's going for that philosophy? Will help you hide the body? Okay, well, maybe a real friend, but some criminal exposure. After a lengthy back in court, the parties apparently agreed there should be no confidentiality order, which is also a bit surprising that the parents of the Laundrie would say that we don't need a confidentiality order so the letter can be exposed. So that's weird. Let's see. The Laundries have argued in court filings they have no duty to the Petito family. I would tend to agree. They don't have any duty to the Petito family in the first instance. They are not legally responsible. The standard rule is no affirmative duty. People do not have affirmative duties to each other unless they undergo a task that imposes on them a duty from the task, or they have some sort of special relationship by law, neither of which is present here. The Petito family might want certain things, but the laundry parents have no duty to provide it. And so their mere failure to provide, their mere failure to act, even if it harms the Petitos, cannot be a basis for a lawsuit. And that feels a lot like what's going on here. It feels a lot like we're using the laundry's failure to reveal information that they potentially knew as a basis of a lawsuit, which is not legally cognizable. Does it make them good people? Does it make them bad people? I suppose it depends in the eye of the beholder. Is it better for a person who knows that they have information that could bring peace to a family that is worried about their missing child to reveal that information? Or is it better for parents to stand by their child and not reveal information that would undoubtedly expose their child to obvious criminal liability, including prison for the rest of their life? What is the greater moral responsibility? I think is an interesting and debatable question. Are the laundry parents bad people because they didn't tell the information that they know that could have revealed the location of Petito and brought peace to their family? Or are they good people because they stood by their son, didn't reveal the information that exposed him, and tried to help him in a time of crisis? How's that work morally? Interesting questions. On the moral front, on the legal front, no duty. So whatever it says about them morally, I think this is the wrong legal call. All right, let's find the letter now and discuss the letter, which will probably undermine everything I just said, I'm sure. All right, hold on. Let's see. All right, hold on. Let's get a copy of this letter and find out how it makes it even more worse. Okay. All right, hold on. We can do this. I can do this. Hold on. I have a plan, people. All right. Shut up. I don't need your damn. No, go away. Stop. Thank you. I don't need your. All right. Turning our attention to the letter, which has been made public this morning, the letter says the following. This was written by Brian Laundrie's mother to Brian Laundrie. And here is what the letter says. I just want you to remember that I will always love you and know that you will always love me. You are my boy. Nothing can make me stop loving you. Nothing will or could ever divide us, no matter what we do or where we go or what we say. We will always love each other. If you're in jail, I'll bake a cake with a file in it. If you need to dispose of a body, I will show up with a shovel and garbage bags. If you fly the moon, I'll be watching the skies for your reentry. If you say you hate my guts, I will get new guts. Okay. Remember that love is a verb, not a noun. It is not a thing. It is not words. It is actions. Watch people's actions to know if they love you, not their words. Therefore, I am certain that okay, let me redo the line. Therefore, I am certain that neither death nor life, nor angels nor the ruling spirits, nor things present nor things to come, nor powers from above nor powers from below, nothing in the entire world can separate our love. Neither hostile powers nor messengers of heaven nor monarchs of earth, nothing has the power to separate us. Romans 8:38, extended version. Nothing can separate us, not hatred nor hunger. I'll redo it. Nothing can separate us, not hatred, not hunger, not homelessness, not threats, not even sin. Not the thinkable or unthinkable can get between us. Not time, not miles and miles and miles. And then it says just Brian Christopher Laundrie, burn after reading. Yeah. I think I want to redo the moral discussion as an outro, so I'm going to redo it as an outro because I think it's an interesting discussion. Okay. Thus, that brings us to the end of this issue for the moment on the ongoing lawsuit between the parents of Petito and the parents of Laundrie. As I've stated, I have significant concerns and significant doubts as to the legal solidity of this cause of action. In my best legal judgment, I do not believe that the words of Brian Laundrie's parents qualify as intentional infliction of emotional distress given the relevant standards. There is significant First Amendment interest in speech. The tort of intentional infliction of emotional distress is hard. It's designed to be hard. It's designed to only appeal to words that are clearly motivated and clearly designed to be outrageous, cruel, and just torturous, right? That's the sort of thing that we're looking for. In my judgment, the words of Brian Laundrie's parents did not rise to this level. So I thought the case should have been dismissed on the motion dismissed. I disagreed with the judge. Turning our attention to the letter and the words of the letter, it raises a really interesting moral question as well as to who's in the moral level, because I don't think it's at all clear personally who's morally right. Most people when they hear about this seem to be strongly of the opinion that Brian Laundrie's parents were morally in the wrong and are morally bad people, but I'm not as convinced of that personally on a moral level. I think the moral level is more complex. It is certainly true that Brian Laundrie's parents had knowledge that they could have given to Petito's parents. This knowledge would have revealed the location of their daughter, who at the time was missing, and who the Petitos, as mother and father, of course, were very, very upset about their missing daughter, as they would be. They had the ability to somewhat end their pain and to bring into being a resolution of this issue. They could have done that, but they kept their mouth silent. So a lot of people have come down on the Laundrie parents as being morally bad people. But of course, we have to look at this from at least one other perspective. Namely, this is a mother who loves their child, as of course the Petitos love their children. If the Petitos love their child and want the best for their child, then it doesn't strike me as morally strange that the Laundrie parents wouldn't want the same thing. And their son has done a very bad thing. They've done an illegal thing. But is it morally better to turn over that information, even if it comes at the expense of turning in and ratting out your own child, who will now have to face this lifelong punishment for what they did was wrong, surely. But you are, by your own voluntary act, exposing them. And is that the morally right thing to do? If you can just keep your mouth silent, if you can just keep that information secret, is that the morally correct thing to do? I think it's more morally ambiguous as to who's in the right or who's in the wrong. So I'd be interested to see what you think about it and all the rest of it. And as to the statements they made, I do not believe the statements they made rise to any legal tort. So I do not think they're actionable, but that's my opinion. So I think legally, this case should not go forward, and morally, I think it's ambiguous. But that's what I think. What do you think? That, for the moment, brings us to the end of the discussion of this case. What these remarks are reminds me a lot of what my mother has said to me over the years. My mom has said to me over and over again, I love you forever. I love you no matter what. I love you. I stand by you. And it's like, well, if she really, really means that, you know, totally wrong morally. I don't know, man. I don't know. I don't know. If a lawyer has information from a client that could really help someone, is it morally different? Even though a lawyer is a stranger and a mom is a mom, is that morally different? If I, as a lawyer, have information that could really end someone's suffering and really bring them joy, but it means exposing a client, am I morally in the wrong for keeping that information secret? And if not, why is my professional responsibility morally absolve me, but the familiar ties don't absolve them? Or am I morally in the wrong? Is every lawyer morally wrong? I don't know. Also, if I become a father someday, because I am a lawyer, that makes things even more interesting. Mm. But it seems like the overall consensus from people, seems to be that the laundries are clearly in the moral wrong. But I don't know if people are really thinking through that in sort of a moral logic. It's like, yeah, I don't know if people are really thinking through that in a moral logic or if it's just sort of visceral. Because they see the crying parents and like, how can you not solve that problem? But like, why is the Petito's love for their child any more important than the laundry's love for their child? Because the daughter is more innocent than the son, but so that should impact the love of it? I don't know, man. I don't know. But that's what I think. All right. Anyways, that's enough moral philosophy for now, as the entire chat probably hates my ass. And I take a more morally ambiguous position. In fact, I don't know. What does it say about my own morality that I think the laundries are probably in the moral right? I don't know. Hmm. It's not clean. It's not pretty. But I don't know. I think I might. I'm certainly the only one I know of in the sort of genres that we discuss. I'm the only one I know of who has taken the position that the laundries are probably, it's at least morally ambiguous, and they're probably morally correct. So yeah, it's tough. It's tough. You need to hear more of the moral logic. Well, I've sort of tried to explain it a little bit. Like, what is it? I mean, the moral logic is what is a parent's duty to their child, I suppose, on a moral level. Is it good? Is it more, here's way of phrasing it. Is it good for a parent to love their child unconditionally? Is turning in a child who's done a criminal thing compatible with loving the child? If you rat them out, is ratting out your own child an expression of love? Is that compatible with love? How about that for an idea? You know? All right. Anyways, we have 3 different U.S. Supreme Court cases today. 2 of them are pretty major. Should we do one of the major ones? Let's do one of the major ones. All right. Let's do this case. All right. This looks a little bit more tenuous in the decision, but we'll see how this goes. Loving your child stops at your child murdering someone. Full stop. Okay, so that means that unconditional love is immoral. Unconditional love is immoral. So love should never be unconditional. Love should be conditional. One of the conditions for stopping loving your child is that they murder somebody. Okay. So if unconditional love is not morally valid, and one of the conditions for stopping loving is they commit murder, here's the next logical question. What other conditions are okay to stop loving your child? What else? What if they injure somebody but don't murder them? What if they steal from somebody? What if they steal something really valuable? What if they engage in a series of really petty things? Is that what is it, like an accumulation thing? Well, yes, unconditional is not 100% all the time. Well, that's what unconditional means. Unconditional by its nature means 100% because it's unconditional. So saying unconditional is not 100% all the time is to say that there is no such thing as unconditional love because now it's conditional. Unconditional by its nature is 100%. Otherwise, it's conditional. Or to say it another way, it's to say it another way, it's a moral imperative. So either it's an imperative or it's not. It's on a spectrum, not black and white. No, on this particular occasion, it is black and white. This is black and white. There is no way to avoid this. It is black and white. Either it's unconditional or it's conditional. There is no alternative. You only have two choices. It's either unconditional or it's conditional. If it is conditional, then what are the conditions? This is black and white. There is no alternative. Nice fallacy? No, it's not fallacy. It's just the definition of words. It's not a fallacy. It's just the definition of words. There's only two possibilities. It is conditional or it is not. There is no alternative. That's not a fallacy. That's just the word. That's just what words means. Unconditional means without condition, means absolute because it's unconditional. That's just what words mean. All right, anyways, carrying on. Well, more the point, Sloan. Their question is how many people would your child have to do before you would do something? I think that's slightly the wrong question. It's not would because it should. We're talking about moral principles. All right. So what I would do and what I should do are two different prospects because we can all falter off our responsibilities, right? So asking what I would do is the wrong question because maybe what I would do is not the right thing to do, right? So the better question is how many wrong things would your child have to do before you should do something? We're talking about the moral imperative. And, is that the same thing as not loving them? Is that the same thing as failing to show love? What does love look like? Does love include snitching? Well, unconditional love does not mean aid and abet and keep out of prison. Well, okay. Well, as to aiding and abetting, we can talk legally. Right? So we can move out of the moral and move into the legal at that point, at least. But there is no law requiring me to snitch. So if your argument is, well, me as a lawyer, I can give you legal advice, right? So if your question is, should I aid and abet my son? My answer legally, I'll turn to the legal. No, that's criminal. Yeah, that would expose you to criminal liability to aid and abet. But it does not expose you to criminal liability to merely keep your mouth shut. So, since there is no legal obligation, and then we'll move to the moral. Anyways, fun times had by all. There's no law requiring you to help an old lady cross the street. That's true. But I don't think anyone would say that mere failure to help an old lady is in of itself immoral. It might be a good thing to help an old lady cross the street, but I don't think anyone would say that your mere failure to do so makes you immoral. So I don't think that's quite analogous. So, yeah. Is it not considered obstruction? No, it's not. No, not legally. No, it's not obstruction of justice to merely keep your mouth shut. No, no. If you're subpoenaed before a grand jury, then you have to testify. But merely keeping your mouth shut is not obstruction of justice. Obstruction of justice requires you to do something, not fail to do something. Obstruction of justice would require you to give bad information to the police, mislead the police, hinder the police, it will prevent them from acting, physically restraining them, giving them bad information, lying to them. But it requires you to do something. Merely keeping your mouth shut is not obstruction of justice, no. Now, if you're subpoenaed, to testify to the police, right? Obviously. If you're subpoenaed to appear before a grand jury, then that's a different story. If you're subpoenaed to appear before a jury, that's a different story. But then at that point, there's legal process. So absent a court order, let's put it that way, absent a court order, no, merely keeping your mouth shut is not obstruction. Okay, great. In today's Supreme Court news, we turn our attention to a woman who owned a house and the government wanted to take the house to pay an unpaid debt. Well, that sounds like that might be fine. She owes the government money. Here is a thing that is worth money. Let's take the thing to pay the money. That sounds fine. Where things get a little bit more tricky is they wanted to keep all the money because the house was worth more than the debt. So they owed some money and the government said, we'll sell it. And it turned out to be more than that. And they're like, we'll just keep it all. What? That sounds a little bit weird, but some states are doing that. So that is the case. Can the government keep all the monies? If you owe them $10,000 and the thing is worth $100,000, can they just keep the $90,000 extra because they want to? Is that a thing? Let's get started with this. Miss Taylor owed a condominium in Hennepin County, Minnesota, that accumulated about $15,000 in unpaid real estate taxes, along with interest and penalties. The county seized the condo and sold it for $40,000, keeping the excess $25,000. She owes $15,000 in the real estate tax. The real estate tax is, of course, associated with the property. Let's take the property to pay the tax. She owes us $15,000. We sold the condo for $40,000. What do we do with the extra $25,000? We like money. Let's keep the money. Yay, money. Wait, that doesn't seem quite right. So the woman over here files suit alleging that they've unconstitutionally retained the excess value of the home above the debt in violation of the takings clause. And God damn it. Okay, you took my property. You took property I didn't owe you. And God damn it. 1, 2, 3, deep breaths. Okay, you took my property. You took property I didn't owe you. That seems like that's illegal. The district court dismissed the suit for failure to state a claim. Yeah, the government gets to keep your money. Why are you sad? The 8th Circuit also affirmed the government gets to keep your money. Why are you sad? So that was the ruling below. All right, so what is the right decision now? The Supreme Court holds that the woman plausibly alleges the Hennepin County's retention of the excess value violates the takings clause. I would tend to think so. Yeah. Her claim that the county illegally appropriated the $25,000 surplus constitutes a classic pocketbook injury sufficient to give her standing. Yeah, she has standing. They took her money. In fact, she is standing over the entire thing. They took her house. The entire thing is subject to due process. Of course she is standing, to raise the issue. You're not allowed to do that. Of course she is standing. What? Yeah. Even if there are debts on the home, Tyler still plausibly alleges financial harm to keep the $25,000. Yeah. I mean, you would think. Tyler has stated the claim under takings clause, which provides private property shall not be taken for public use. Whatever remaining value from a tax sale is properly protected under the taking clause depends on state law, traditional property law principles, historical practice, and court precedent. Though state law is an important source of property rights, it cannot be the only one, because otherwise a state could sidestep the takings clause by disavowing the property interest in assets. So yes, property law is typically defined by states. This is not controversial. Homes, of course, in particular, are defined by states. The land, of course, in particular, is typically defined by states. This is typically a matter of state law, what property is and how you own it. Now, the state coming along and suddenly saying, hey, wait a second, this isn't property anymore. So we didn't take property because it's not property, because we say it's not property. Obviously, that could be a real problem, right? If the state gets the right to define what property is, and it wants this thing, one of the things the state might do is just simply say, this isn't property, so we didn't take property. So obviously, no, we're not that dumb. History and precedent dictate that while the county has the power to sell the home to recover the debt, it couldn't use the debt to confiscate more property than was due. Doing so effected a classic taking in which the government directly appropriates private property for its own use. Yes, that makes logical sense. She has a debt on the property. It is a tax debt on the property. We seize the property to pay the debt. We have paid the debt. Incidentally, if the property had not been sufficient to pay the debt, the county would want more money. So if the property only sold for $10,000, then they'd still say, hey, you owe us $5,000 more, right? It wouldn't typically extinguish the debt. So if they say, okay, the property only sells for $10,000, you still owe us $5,000. If the property sells for $40,000, we get to keep the $25,000. How does that make any sense? It doesn't. The principle that a government may not take more from a taxpayer than they owe is rooted in English law and can be traced back to the Magna Carta. Yeah. From the founding, the government of the United States could seize and sell only so much of land as being necessary to satisfy the tax. Yeah. I mean, that makes logical sense. The government has the right to tax. The federal government has the right to tax. The state government has the right to tax. Taxes and death are the only things certain in this world. So can government tax the land? Sure, they often do. What happens if you don't pay the debt? We'll take your land. Okay. I mean, fine, but only take it as much as you owe. That sounds better. 10 states adopted similar statutes around that time, and the consensus the government could not take more property than was owed was held through ratification of the 14th Amendment. Yeah, I mean, this is pretty ancient common law. This goes as far back as you like. So we just like money for the sake of money has been illegal for a very long time. Today, most states and the federal government require excess value to be returned to the taxpayer, which is incidentally true also, by the way, of private debt, that is secured debt. For example, a car would be the most common way you would have secured debt, or for that matter, a home with a mortgage. The same thing would be true. So you own a car. You have gotten a loan for the car. You own a house. You have gotten a mortgage for the house. What happens if you stop paying the loan on the car? What happens if you stop paying the mortgage on the house? Well, the bank is going to take your car or your house to satisfy the debt. What happens then? Well, according to the law, they have to sell the house in a commercially reasonable way, which typically means an auction. That's how you do it, typically at a public auction. It doesn't have to be a public auction, but that's the way you typically do it, right? You have a forfeiture sale You publish it in the newspaper. You say anyone who wants to bid on this house, typically show up at the house itself, is typically where these things are done. Show up at this date, at this time, and bid on the house. Great. It's a car. We put it up in a car auction. They happen all the time. Great. We sell it in a commercially reasonable way. What happens if the house or car sells for less than the debt? You still owe us money. What happens if the house or car sells for more than the debt? You have to get the money back. Okay? It's in the UCC, damn it. All right? We have to give you the money back because it's not ours. All right? We sold the thing. There's a windfall. Whose windfall? Your windfall. It's your money, damn it. So what's true of a private party is still true of the government, amazingly enough. The courts present have long recognized the principle that taxpayers entitled to surplus. The relevant cases that we've discussed in our precedent does not change that. The ordinance challenge in the relevant cases did not absolutely prejudice an owner from obtaining a surplus, but instead simply defined the process through which the owner could claim the surplus. So how do you go about claiming the surplus? How do you go about asking for the government to give your money back? Maybe there's a process to do that. You know, it's due process. Okay, that's fine. Give them due process. That's cool. So you have a particular process to ask so that they get the money back. That sounds fine. That's cool. Minnesota's scheme in comparison, not so much with due process or any process of any kind. So our precedent says, yes, state, you can define due process and you can have them go through a particular method of doing that. But Minnesota's here, how about like no method? How about we just get to keep the money? No. Significantly, Minnesota law itself recognizes in many other contexts the surplus. For example, the car and house in the mortgage and car loan examples we've been talking about. If a bank forecloses on mortgage, state law entitles surplus. Yep. And collecting past due taxes, Minnesota protects taxpayers' right to surplus. Minnesota may not extinguish the interest it recognizes everywhere else to avoid paying just compensation. Yeah. If a private party were to do this, you'd get the surplus. So why are we different? Because we're the state. No. The court rejects the county's argument that the Tyler over here has no property interest in the surplus. This should be good. She doesn't have a property interest in the surplus. Why? Let's figure that out. Why? Because she constructively abandoned her home by failing to pay taxes. Wow. That's nice. She abandoned her home by failing to pay the taxes on the home. Wow. That's some bullshit. How deep do we have to try to find that argument? Abandonment requires a surrender or relinquishment of all rights of a property. Yeah. So if you abandon property, any property, by the way, if you abandon any property, then yeah, it's abandoned. So it's not yours anymore because you gave it up. If you throw a piece of paper in the trash, you've abandoned it. It's not your piece of paper anymore. If you leave your home because you don't care about it anymore, then it's abandoned property. Can the government take that? Sure, because you don't want it. It's not your property anymore. But it requires you to, actually do that. It requires you to throw away the piece of paper in the trash. It requires you to do the equivalent of that for a house. I didn't pay property taxes, ain't it, chief? Minnesota's forfeiture law is not concerned about the use of property, only the failure to pay taxes. The county cannot frame that failure as abandonment of the entire property. Roberts files an opinion for a unanimous Supreme Court because, yeah, this is pretty easy and this is pretty dumb. So yes, states everywhere cannot just seize your property and keep all the excess because they feel like it. No. Thus, that brings us to the end of the case in which the United States Supreme Court kind of states the obvious. If you owe money to somebody, anybody, and it's a secured debt, such as a car loan is secured to the car, such as a mortgage is secured to the house, such as often equipment in a commercial context is secured by a loan, and the loan is secured to the commercial thing, the industrial equipment. If you have a secured debt of any kind and you default on the debt, one of the remedies is the people who gave you the loan get to take the thing. That's what's in the nature of it being secured. It's a secured debt. So they get to take the thing to pay the debt. So taxes are like this in this respect, okay? It's a secured debt against the house. Okay, fine. We'd like to take the asset to pay our debt. Fine, no problem. Hey, wait, there's extra money at the end. We'd like to keep the money. No, that doesn't work in a private context. It doesn't work in a state context. You own a car, you own a house, you own some industrial processing equipment somewhere. It turns out that the equipment is worth more than the debt. Turns out the car is worth more than debt. Turns out the home's paid more than debt. You get a check. But the government said, we get to keep it because we like money. And no, this is very, very illegal. So the Supreme Court stating the obvious this morning, and that brings us to the end of discussion of this case. An orthodontist could take the braces back. I don't know. It has to be a secured debt. Secured debt gets into secured transactions. It's a special part of the UCC on how they become secured. And I don't think you can secure debt something that is like installed inside of a person. I don't think that's a thing. I don't think that you can do a secured debt for someone's pacemaker or something. I don't think that works. But it's covered by secure transactions merely because it has to be. There's a special process for it. I believe it's UCC 9, if memory serves correctly, for secured transactions. So if you want to know more, consult your uniform commercial code. I believe it's section 9. So push the button. If they had a mortgage, why weren't property taxes and insurance not included in the payments? Because those monies are owed to other people. That's why. If you have first of all, I don't know that they had a mortgage in this particular example. So I don't know that they had a mortgage at all. So, but assuming they did have a mortgage, if you have insurance as a homeowner, that is money that you owe the insurance company, not the bank. If you owe taxes to the government, that's money you owe to the government, not the bank. So why would it be included in your mortgage? It's not part of the money that you owe to the person who gave you the loan. Do I want to cover Ron DeSantis announcing his presidential bid this morning? I mean, it's more political than legal. I'm not sure there's really anything for me to say about it in the context of this channel. But if you missed it, Ron DeSantis announced that he wants to be president. So I don't think I'm going to cover the story. There's just nothing for me to say in the context of this channel. All right. Is my favorite color green? Not in particular. It's just the color of shirt that I decide to wear today. I like to mix it up. I'd say my favorite color is probably blue or dark blue. But today I wore a green shirt. And when I pushed the button, it came up with this background. So that's what we're doing right now. My takes on the new Murdoch charges, I mean, I mean, what more can be said, right? I mean, it's like, the guys, yeah, so Ron DeSantis is the governor of Florida. Sorry, Canadian friend. Ron DeSantis is the governor of Florida. Very popular politician in the United States among the right. And he has announced that he's running president, and so is Donald Trump. So that's what's happening. So, yeah. All right, let's discuss something different. All right. You Rakita thinks Murdaugh is innocent. Well, I don't know whether or not Rakita thinks that. I don't know exactly what he thinks in this domain, but I was skeptical of the jury's verdict on a legal level, which isn't the same thing as believing that he didn't do it, depending on what you mean by innocent, of course. Right? I think that there were. I'm not sure that I would have voted to convict. My inclination would have been to vote not guilty based on the relevant legal standards. So maybe that's what Rakita thinks, because that's kind of also what I think. I think that there were enough areas of reasonable doubt, and I've expressed those areas of reasonable doubt. Yeah, I think that the state's timeline is really, really tight. And I think that it would be very difficult for him to have executed it within the time frame that the state is talking about and not get evidence like all over himself and not in the car and things like that. And to this, a lot of it's speculation. So yeah, I think I would have voted not guilty. Whether or not he actually did it, of course, is a separate issue, but I don't think the state really proved it to my mind. But that's me. Of the murders themselves, the financial crimes he's totally guilty of. I mean, the financial crimes, they've gotten dead to rights on the financial crimes. But the murders are a little bit more sketchy. Yeah. Yeah. So I think the convictions on the murders are legally questionable in the first instance. On appeal, of course, as we've discussed many times before, right? Presumption of innocence is over now. So this is one of those interesting issues too. Like, if I were a juror, I think I'd be inclined to vote not guilty. If I'm the Court of Appeals reviewing this on appeal, right? Then, like, well, the fact that the evidence is a little bit wishy-washy in my view is not going to do it for me on appeal. So I can't overturn it for that reason, right? I can't substitute my judgment for the jury's judgment. So my decision, my fact that I would have voted not guilty is not going to in and of itself allow me to reverse. I have to find a legal error. And there is some of that to be had, to be sure. In fact, in particular, the most egregious legal error in the case is just the amount of the financial testimony that was brought into the case, right? Because it's so prejudicial. So it's a 403 problem. So that's the most obvious grounds to reverse, to my mind, is the length and amount of the financial information that was brought into the jury trial seems excessive. Assuming that it was relevant in the first place, which is also questionable, I think it poses a serious 403 problem for being substantially more prejudicial than probative. So as a court of appeals, I'd be taking a serious look at that issue. But yeah. Yeah, and there are other like the demonstratives and exhibits. Yeah, there are other problems in the case, right? But as we've discussed in some detail, you're not entitled to a perfect trial. You're entitled to a fair trial. So sure, there are other aspects of the trial that you could appeal on, like the TARP or like other aspects of the testimony. You could absolutely appeal, but they probably in and of themselves are not sufficient. Maybe in combination they are, but the most glaring single error is the financial stuff. So was the thing with the TARP okay? There were other aspects of the trial that you could point at, but the other aspects of the trial are more in the nature of they're more in the nature of uh errors that are harmless legally. So yeah. Also, SLED, of course, potentially lying / misleading the grand jury would also be a secondary issue. So the grand jury problem would be a obvious secondary issue. So primary issue is the 403 problem for the financial stuff. Secondary issue is the SLED's testimony before the grand jury. And miscellaneous would be number 3. In copyright news, the US Supreme Court has been asked to take a look at a case dealing with Google's use of song lyrics in its database. So song lyrics are, of course, copyrighted along with the music and arrangement itself, but the lyrics, of course, are also copyrighted and often held by a different copyright holder. And Google provides the music lyrics in much the same way that it has provided the text of books in the past. In that case, of course, also went to the US Supreme Court. Can Google provide scanned copies and text of books? The answer was yes. And now the question is on the same thing with sound lyrics. The difference, of course, being in the case of song lyrics, perhaps we're capturing the entirety of the thing as opposed to just an excerpt of the thing. Because in the case of books, typically they don't make the entire book available, just pieces of it. But that's perhaps a difference. So should the song lyrics come under a different analysis? The Supreme Court's been asked about this, but the Biden administration doesn't think that the Supreme Court should look into it. So let's take a little bit more of a look at the case. The Biden administration's Solicitor General said the Supreme Court should not review a ruling that was won by Google against the song lyric website Genius over Google's alleged copying of the lyrics transcription. So this was part of a standard process, by the way, in the calls for the view of the Solicitor General, which is very, very typical when the Supreme Court is looking at cases and they have a particular interest in them. They often ask the Solicitor General for their opinion on whether or not they should take the case. It is a generally good sign the Supreme Court is interested in a particular case. And in this case, they say no, which of course doesn't preclude the Supreme Court from taking the case. They very well might anyway, but they don't think this is a particularly good case for the Supreme Court to take. So that's their opinion. The Solicitor General said in court brief that justices should let stand the Second Circuit Court of Appeals. The Genius case was preempted by federal copyright law, which is also another interesting aspect of intellectual property. There is some state copyright law still floating around. Not much of it, but there is a little bit of state copyright law still floating around, particularly in New York, where this case was brought. So in intellectual property law, when it comes to copyright has not necessarily completely preempted the field. States still do have their own copyright law, and occasionally cases do turn on it. And New York, which is a major source of publication, particularly in relating to books, which is what New York is more known for in that sort of publication domain, New York does have its own copyright law. So one of the reasons they tried to sue was under New York State specific copyright law. But the Court of Appeals said that in this particular instance, while New York might be allowed to have copyright law in a general sense, in this particular instance, this particular aspect of New York copyright law was preempted. So while the entire field of copyright law might not be preempted, this particular aspect was. So this turns on federal law in a way that completely quashes the state law. So a very interesting aspect of intellectual property law in that domain. Genius, of course, itself does not own the copyright to the lyrics because those would be owned by the people that created the lyrics, the original person who created the work. It accused Google of violating its terms of service by stealing its work and reposting it on Google web pages, which is interesting as well, because if they don't own the copyright to the lyrics themselves, then they may not have an interest in what Google is doing. Maybe the original publisher does, but not this people. Because if like we stole your work, well, it wasn't your work. You merely got it from somewhere, wherever, don't know, but you know, you don't have an interest in it. It's not something you came up with. The Second Circuit last year upheld the Manhattan Federal Court's decision that Genius's breach of contract claim was really a copyright claim that could only be pursued in copyright law. So this is another thing that often comes up in intellectual property, particularly copyright, but not exclusively copyright, is this idea about contract versus copyright. And so it is often the case that someone will bring a lawsuit that is framed as either a copyright or as a contract, depending on which is more convenient. But the courts, in looking at it, will say, no, your complaint is really rooted in the other. So there is an issue about when this is thing. So it's like, okay, you accessed our website, you violated our terms of service. That's a breach of contract. But here the court's looking at it, saying, no, your underlying issue is really rooted in contract. And you see this kind of thing not infrequently. And it's like, yes, you can only bring this action this way and not this way. And so that makes perfect logical sense. You see a lot of cases along those lines. Yeah, Sackett versus EPA, I have it. We're getting to it. I have all the Supreme Court cases today. Don't worry. We're just going in between, breaking up the flow a little bit. We'll get there. But thank you for the super chat. Google said that it holds a license to the lyrics. So it says we have permission for the lyrics. And Genius wants to ignore the copyright and invents new rights through a purported contract. So, no. It's like, if we have license to the lyrics, then, well, if we license it, that certainly solves that problem right up. So do we need to license it? Who knows? Maybe that's just the Google book case all over again. But we are licensing them, so that solves that problem. And you want to try to gain control over this through this breach of contract, but no. So, yeah. The Solicitor General of the United States criticized the Second Circuit's suggestion that copyright law categorically bars contract claims that are based on promise not to copy, which, fair enough. Yes, again, I don't think it's a categorical thing. I think categorical is a little strong here because, again, you get into this tension between the difference between intellectual property and contract, and those cases can get very, very technical. So I'm saying this is categorically IP and not contract. That language is probably not right. And then, of course, also the barrier between state law and federal law when it comes to copyright. Again, categorical, that language is a little strong. But the Solicitor General recommended declining the petition because it wasn't clear Genius could prove it at a valid contract. So, we are critical of this language, which I think, to be fair, you should be critical, but the underlying conclusion is probably correct on this basis, that this is not really an issue of contract. This is really an issue of IP, that you've pretended to be a contract, and we're saying it's not really a contract, so go away. Genius's attorney over here said Wednesday that there's an entrenched circuit split on whether and when breach of contract claims are preempted. I mean, I don't know whether or not it's exactly a circuit split or not. I suppose that depends on how you view it to some degree. I would agree that there are cases certainly of varying descriptions when it comes to the issue of breach of contract on the one hand and IP of the other hand. IP of all kinds, typically though copyright is the most frequent, but you even do see this sometimes in trademark and patent cases. Patent would probably be the second most common. You do sometimes see this where it's like, oh, you're bringing this as a breach of contract claim, but what it really is a patent claim, or the other way around. But, there's a lot more copyrights out there than there are patents. So it's not surprising that there's a lot more case law on it. Is it exactly a circuit split? I don't know that I describe it that way, but you certainly could. It's more of a very fact-intensive inquiry. So I think the dispute is more in the nature of facts than in the nature of law. But, you could obviously come to a different opinion on that issue. So I don't begrudge Genius's attorney for saying they believe a circuit split exists. I'm not sure that I agree with them, but I understand their perspective despite my disagreement. So fine. Google spokesman said the company does not crawl or scrape websites to use source lyrics, calling the claim meritless. So they also dispute, in fact, that they are actually doing this. So first of all, we disagree that we're doing it, but even if we are, it's not illegal. So, okay, that's fine. That's called alternative pleading, which you can do, of course, although sometimes it gets a little bit more tricky, but less tricky when you're on pure law. Trying this before a jury, not a great idea. Trying it in a court of appeals, more good. Like, we didn't do it at all, but if we did it, it wasn't illegal. That's called alternative pleading. You can do that, and that's what they did here, so fine. thus, that brings us to the end of the case of Google when it comes to song lyrics. They were sued by a company called Genius, who said that they infringed on their song lyrics, the idea being breach of contract. On the law, whether it's a breach of contract or IP, gets very, very factually specific, and the cases are a bit unclear, or at least it's unclear in a way that seems to suggest a unified rule. Is that a difference of opinion as it comes to law? I'm not so sure it is. It's more fact, but maybe it's law. So the fact that this could be actually an underlying legal dispute, okay, maybe it is. But this is not a great case to resolve that issue because it doesn't really bring the issue, assuming it exists at all, into sharp focus. So the Solicitor General saying, probably not a great case for the US Supreme Court to take makes logical sense. Of course, the US Supreme Court might do it anyway, depending on their views of how they view the question. But in their calls to the view of Solicitor General says no. So we'll see what the Supreme Court does, and that brings us to the end of discussion of this case. Man, we are really burning through time today, aren't we? These are not going to be short videos when we're done. Holy shit. All right, well, that's fine. All right. Because Jason mentioned Sackett versus EPA, let's discuss Sackett versus EPA. I am happy to help you and meet your needs. So let's discuss Sackett versus EPA. All right. What is the Solicitor General versus Attorney General? They're just two very different roles. The Solicitor General is technically the fourth in command at the Department of Justice, in case you care. And in order of seniority, it is Attorney General, Deputy Attorney General, some other kind of deputy, and then Solicitor General. I know they're fourth in rank. But the Attorney General of the United States, basically, to break it down, the Attorney General of the United States basically decides what federal law enforcement will do. They're often called the Chief Police Officer of the United States, which is a pretty apt description, right? Because they are the ultimate authority on whether or not cases will be prosecuted within the United States government. So they're sometimes called the Chief Police Officer of the United States because they're the ultimate authority on whether or not to prosecute a case. The Solicitor General of the United States, in my view, is a much better job. The Solicitor General of the United States' job is to argue the Department of Justice's position before the courts. So they are the DOJ's representative in court. So they're the one that do the arguments. And of course, most notably, they're the one that do the oral arguments at the US Supreme Court, which I think is a much more kick-ass job. So that's the Solicitor General. Their job is to, and also interesting in terms of like the nomenclature of it, it's also interesting because the term solicitor in like the UK, it is a designator for someone who doesn't go to court very much. So it's an interesting distinction as well in the way we use the nomenclature, because we use it in a way that the UK doesn't use it. And also some states also call their prosecutors solicitors, which is also kind of hilarious because of this distinction. So in the UK, if you go to court and you argue your courts, if you argue in court, you're a barrister. If your work is transactional and paper-based, you're a solicitor. Now, it isn't exactly that clean, but that's major the distinction. So we'll just pretend it's that clean and call it a day. All right. If you go to court and you argue before a judge or a jury or before a court of appeals, you're a barrister. If you do transactional work and you do paperwork, you're a solicitor. So it's interesting because in the United States, we call the person who argues in court a solicitor, which is kind of hilarious, as opposed to a barrister. So that's just kind of hilarious. Just one of those things, man. One of those memos that got lost on the pond. Yeah. Where are my swoops? Well, I have pushed the button. Push the button. There we go. I have pushed the button. All right. AG, deputy AG, associate AG. Yeah. And then solicitor. Yeah. I forgot what the deputy to the deputy was called. They called it associate. Yeah. I think solicitor general is a much better job. I'd much rather be solicitor general. Make me solicitor general for life, yo. I'm a very happy camper. You know? Serious. I'm a much happier camper. Maybe solicitor general for life. That'd be great. The current solicitor general kicks ass. They often do, by the way. And it's, there occasionally are not great ones, but this one's pretty good. She's a former Miss USA contestant as well. She won her state like twice, teen and once as an adult, in beauty pageants. So she's literally a national beauty, and also she's incredibly wicked smart. It's not fair. One person should not have it all, damn it. But she's really, really good. She's really, really good. We've heard some of her arguments that she's really, really good. Damn it. She has it all. Shit. Yeah, she's definitely my type of woman. If she were single, I'd take that in a hot minute. But sadly, she's married, and I don't think she knows I exist. Although she'd like to hire me, I'm available. Because I would love to be an assistant solicitor. It'd be the coolest job in the world. Please hire me. All right. In land ownership rights news, we come to the case of Sackett versus EPA. The Sacketts own a piece of land. This piece of land does not have water on it, but it is across the street from some water. So the EPA says that your land is part of the waters of the United States. Despite it not having water on it, despite it being across the road from some water, it is water enough. So you're not allowed to do what you want to on your land because it's part of the waters of the United States, and this would pollute the waters of the United States, so you're not allowed to do this. So the Sacketts over here are like, but we don't have water on our land though. And the EPA is like, we don't care. So in today's case, we're going to decide how far the EPA has when it comes to regulating water on property, which incidentally, by the way, is somewhat of a major issue, perhaps more major than you might think. The EPA gets involved in waters of the United States on lands quite frequently, including by preventing development. So this EPA power is fairly significant and manages to worm its way into quite a few people's lives. So let's figure out what the rule is as it relates to this. Let's get started with this. Yeah, the EPA is a bit of an overreach. That's one way of putting it for sure. It's expansive. It's expansive. The petitioners, the Sacketts over here, purchased property that was near Priest Lake, Idaho, and began to, improve their lot in order to build a home on it. So the EPA over here said that their property contained wetlands, and doing the improvements that they were doing to their property in order to build on it would violate the Clean Water Act, which prohibits discharging pollutants into the waters of the United States. So we bought a piece of land. It is not quite ready to build a property on. We need to do some things to the property to make it suitable to build a house on. We are starting to do the things to improve the property to build the house on. The EPA over here is like, you are polluting the waters of the United States, even though there's no water to be found. The EPA ordered the Sacketts to restore the site to its original condition and threatened penalties of $40,000 every day. The EPA over here is definitely doing some mafioso thing over here. Sorry you bought your land, everything. Please remove it, please restore it, and if you don't, we're going to charge you $40,000 each and every day because you don't bend to our will. So the EPA definitely playing some hardball over here. The EPA classified, excuse me. There we go. The EPA classified the wetlands on the lot as waters of the United States because they were near a ditch that fed into a creek, which fed into a lake, which was across the street. So across the street was a ditch that went into a creek, that went into a lake, and the lake itself is navigatable. So therefore, the creek is navigatable, therefore the ditch is navigatable, therefore your land is navigatable waters. So I suppose get a boat and start cruising around the completely dry land that is navigatable water. All right, do we need a boating license? Is that the problem? Unclear. The Sacketts over here saying that this doesn't make any sense, sued saying their properties are not waters of the United States because there's no navigatable water to be found here. We don't see any. The district court entered summary judgment for the EPA. Looks fine to us, says district court. We see lots of water. Water everywhere on your land. We don't know what you're talking about. We see water all over the place. The Ninth Circuit said, yeah, that sounds great to us. That the Clean Water Act covers wetlands with an ecologically significant nexus that has traditional navigatable waters and satisfy the standards. So basically close enough is the short. We have the right to protect the navigatable waters of the United States, and this is close enough because it has a nexus that's close and a ditch and a creek and blah, blah, blah. So can the EPA regulate this dry piece of land? Let's find out. The Supreme Court writes that the Clean Water Act's use of water in the United States refers only to geographical features that are described in ordinary parlance as streams, oceans, rivers, and lakes. So when we said water, what we meant was water. Water is what water means. Okay. And adjacent wetlands that are indistinguishable due to a continuous surface connection. So, water and also waters that are that feed into the water. So water is water. Wow. Okay. To assist jurisdiction over adjacent wetland under the Clean Water Act, a party must establish that first, the adjacent body of water constitutes water of the United States. Waters of the United States are a relatively permanent body of water connected to traditional interstate navigatable waters. So they have to be navigatable waters that, you could take a boat on. And if, it's only sometimes water, because it's only sometimes a river, then, okay. But it has to be relatively permanent. It can't just be, completely intermediate. So it has to be a, somewhat fixed body of water that is water that you could navigate on. Second, the wetland in question that is feeding into the water must have a continuous surface connection with the water that would make it difficult to determine where one water ends and another water begins. So if we get into this sort of line drawing problem of, hey, where exactly does the lake stop? Because there are some marshy areas around. Is that a lake? That's a little bit marshy. And we can't quite decide where the lake ends and where it begins. So we'll include the marshy areas that feed into the lake. That sounds okay. We can cover that much. The uncertain meaning of waters of the United States has been a persistent problem that sparks decades of agency action and little, and apologize. I am telling the EPA that. I'm reading the case. I am telling the EPA that. I'm telling them as we speak. We're all learning. The uncertain meanings of waters of the United States has been a persistent problem, sparking decades of action and litigation. Yes, a lot of the time, a lot of people who own a lot of property and the EPA gets involved in their turf. And obviously this has been litigation, a lot. Resolving the applicability to wetlands requires review of history surrounding the phrase. So we have to figure out what are wetlands now so that we can try to put this problem to bed. Let's see if we can do that. During the period relevant to the case, the two federal agencies charged with enforcement, the EPA and Army Corps of Engineers, who, by the way, are just complete badasses. So whatever they do in terms of their regulatory schemes and their regulatory overreach, we can certainly condemn. But I just want to say the Army Corps of Engineers are complete badasses. The stuff they do is truly amazing. In terms of water and water management, holy shit, the Army Corps of Engineers is cool. Just wanted to make that clear. Similarly, define the waters of the United States to broadly encompass all waters that could affect interstate or foreign commerce. All waters that could affect interstate or foreign commerce, that just sounds like all water everywhere, because water evaporates. And maybe the water will evaporate and go over to, I don't know, Europe and rain. And so it affects interstate commerce. It's an international relations problem, what I'm doing on my land now. The agencies in question gave expansive interpretation to wetlands adjacent to water, defining adjacent to mean bordering, contiguous, or neighboring. So, as always, when we gave the agencies the power to interpret the law, as we do under Chevron, and we said, hey, agencies, here's a law, please interpret it. Amazingly enough, they interpreted it in a way that gave them more power. What are the odds? In a different case, the court confronted the Army Corps of Engineers' assertion of authority under the Clean Water Act over wetlands that actually abutted navigatable waters. Although concerned that wetlands fell outside the traditional notion of water, because it in and of itself is not navigatable, like a lake or river, the court deferred to the Corps, reasoning that the transition from water to solid ground is not necessarily, or even typically, an abrupt one. Sounds like Chevron to me, my friends. Sounds like Chevron to me. We are deferring to agency interpretation. So sure, it's navigatable waters. So that sounds fine. My disdain for Chevron continues with every passing moment. Following a case, the agencies issued a migratory bird rule, extending the Clean Water Act jurisdiction to any water or wetland that are or would be used as a habitat by any migratory bird or endangered species. So if waterfowl use your water, then, that's those birds are traveling in interstate and even international commerce. So we have control not only over the birds, but the water, because that's water enough, because the birds use it. Okay, unclear how this impacts my bird feeder. The court did reject the rule after the court The court did reject the rule after the Corps sought to apply it to several isolated ponds located wholly within the state of Illinois, holding the Clean Water Act does not extend to ponds that are not adjacent to any open water. So, okay, fine. We did find a limit somewhere. So we said, okay, the birds land in the ponds and the ponds are part of the waters. The Supreme Court, finding a limit to Chevron somehow, says no, those are not part of the waters. They are isolated ponds. They are not part of the navigatable waters. They're not part of the lakes and the rivers. They're just small ponds. And even though the waterfowl use them sometimes, no, they're not navigatable waters. It's a pond. So we did find a limit somewhere. The agencies responded to this fairly clear-minded direction by instructing their field agents to determine the scope of clean water jurisdiction on a case-by-case basis, which of course wouldn't be abused in any way. So just figure it out case by case, agents. I'm sure you won't abuse this power to give you power when you shouldn't have power. Okay. Within a few years of the Army Corps of Engineer over here saying, you figure it out, the agencies, including the EPA, had interpreted their jurisdiction over the water of the United States to cover somewhere between 270 and 300 million acres of wetland, and virtually any parcel of land that contains a channel or conduit through which rainwater or drainage may occasionally or intermittently flow. Hey, does rain fall on your land? Does rain fall on your land? Does the rain that fall onto your land sometimes leave your land and go into water? Hey, now your land is part of the waters of the United States because it rains there sometimes. Because the rain moves and it goes into water. So the rain that falls on your land, it's wetland now. It's raining. Can't you see how wet your land is? It's raining right now. Great. Against the backdrop, the court in a different case vacated a lower court decision that held the Clean Water Act covered wetlands near ditches and drains that are emptied into navigable water several miles away. So again, somehow finding a limit to Chevron, somehow, some way, we said, okay, we can't help noticing, EPA, that when we said wetlands that are continuous with the lakes and rivers, so that it's unclear where the wetland begins and the lake starts because they're continuous and there's no interruption. We can't help noticing that when we said that. You said, how about wetlands near ditches that will somehow drain eventually into a navigable water that's several miles away? We can't help noticing that the area between the wetland and the lake is somewhat separated. So, no. So we said we can't do that. But as the reason we can't do that, the court could not agree. So we're like, you can't do that, but we're not sure why. So that's really helpful to the lower courts and the EPA. Yeah, you can't do that, but we're not sure why you can't do that. 4 justices concluded that the Clean Water Act coverage was limited to certain relative permanent bodies of water that would be connected to traditional interstate navigable waters and wetlands that, as a practical matter, are indistinguishable. In other words, continuous. Justice Kennedy, concurring only in the judgment, wrote that the Clean Water Act jurisdiction over adjacent wetlands requires whatever a significant nexus is. What the hell is that? So maybe not continuous, maybe significant nexus. What does that mean? That's a good question. But it would require whatever the significant nexus is between the wetland and its adjacent navigable waters, which exists when the wetlands, either alone or in combination with other lands, significantly affects the chemical, physical, and biological integrity of the water. What? What does that mean? What does that mean? But if it significantly impacts the together or alone or in combination, similar lands and the region and integrity, how do I apply that? That's a really good question. I don't know. Following this confusing case law, the relative agencies brought nearly all water and wetland under the jurisdiction of the Clean Water Act by engaging in a fact-intensive, significant nexus determination that turned on a lengthy list of hydrological and ecological factors. So the EPA over here, is given a case that says, yeah, these wetlands are not wetlands enough, but we're not going to tell you why. And just figure out if it has a significant nexus, which, to be fair to the EPA, isn't particularly helpful. How's the EPA supposed to figure this out? I don't know. So I have a little bit of sympathy for the EPA, just a little bit though, because they're the ones abusing their power, but the instructions aren't particularly clear. So they do an open-ended inquiry that basically just sweeps in all water everywhere because, they don't know what the rule is and they'd like more power. So between a combination of the Supreme Court not telling them and their own greed of power, let's say that everything is a significant nexus because, water evaporates and eventually will fall on the land and contaminate the water and blah, 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 blah. Landowners who even negligently discharge pollutants into navigable waters without a permit face criminal charges. So fair enough, if you, pour oil into the lake, that's going to be a problem. Please don't do that. So yes, that makes sense. As things currently stand, the agencies that maintain the significant nexus test is sufficient to establish jurisdiction over whatever adjacent wetlands means. Because by adjacent, we mean somewhere vaguely near is apparently adjacent. By the EPA's own admission, nearly all waters and wetlands are susceptible to regulation under the test, putting a staggering array of landowners at risk of criminal prosecution for such mundane activities as moving dirt, because the dirt might be contaminated and it goes into the water. So what adjacent means is anywhere vaguely nearby. Okay, fine. All right, so having specified that part of the EPA's standard, the court next turns its extent to the geographical reach. How much does this sweep in? Because the EPA has defined it to mean all water everywhere. How much is that? To make sense of Congress's choice to define navigatable water as being the waters of the United States, the court concludes the Clean Water Act's use of water encompasses only those that are relatively permanent, standing or continuously flowing bodies of water, forming geographic features that are described in the ordinary parlance as streams, oceans, rivers, and lakes. So waters of the United States means streams, ocean, rivers, and lakes that are navigatable so that you could put like a boat on it. So, okay. All right, fine. This reading follows from the Clean Water Act deliberate use of the plural waters, which refers to those body of water listed above, and also helps to align the meaning of waters of the United States with the term navigatable waters. So we are going to solve this problem, at least in part, by saying that waters of the United States means navigatable waters, means rivers and lakes and oceans and streams. Okay. More broadly, this reading accords with how Congress has used the term waters elsewhere in the Act and other law. The court has understood the Clean Water Act use of water in the same way. So we think waters of the United States are the navigatable waters of the United States. Okay, fine. The EPA's insistence that water is nationally read to encompass wetlands because the presence of water is universally regarded as the most basic feature of wetland proves too much. So yeah, this is an argument that is sometimes what we call too clever by half, right? It proves too much, which is always a problem when you come to court, right? If your test proves too much, if it sweeps in too much, if it goes too far, right, that runs into a problem. So we appreciate your too clever by half argument that wetlands are water because it has the presence of water. But that argument, if we believe that, would sweep in all water, which is exactly what you've done, incidentally. So yeah, wetlands include the water, but they are not waters of the United States because they're not navigatable waters for this purpose. You know, you can't put a boat on it and navigate them, right? That doesn't work. It's also tough to square the relevant exclusion of isolated ponds from the idea of what adjacent wetlands are to covered water. So we already said the isolated ponds are not waters. So that would also apply to wetlands for the same exact reason. Finally, it's difficult to see how the state's responsibilities and rights in regulating water would remain primary if the EPA is this far, which again, as it relates to this, right, the states may have their own regulations when it comes to the waters of their state, which of course, they are typically free to do. States can go further. The question is, what does the Clean Water Act require? Not what states can do. And states are supposed to be primary. So if we said EPA, you have control over all the water, what does that leave for the states? Not much. So we can't do that. Statutory context shows that some wetland does qualify as water. So yes, perhaps some wetland does qualify as water, but that doesn't mean all wetland qualifies as water. You can't, or that all water is wetland, or that a house that has some rain falling on it is a wetland. It doesn't mean those things. Specifically, the relevant law which authorizes states to conduct certain permitting programs specifies that discharges may be permitted into any water of the United States except those of traditional navigatable waters, which would include wetlands adjacent thereto, which would suggest at least some wetlands must qualify as water. So again, to the extent the wetlands are indistinguishable, then the federal law even says that's protected. So fine, the wetlands that are one of that where we can't draw a clean line between the wetland and the lake, or the wetland and the river, or the wetland and the ocean, as the case may be, fine, we can do that. But the relevant law cannot define what wetland means when the Clean Water Act regulates because it's not an operative provision that defines the act's reach. So some special area of law says that states can permit dumping of stuff other than the navigatable waters, which in this particular instance includes wetlands. But that particular citation to wetland in that particular part of the statute does not read on the entire statute. So Congress, when it wrote a specific part of the statute, did use the term wetland, to be sure, as it relates to what states can and cannot permit. So that's fine, but they used wetland in that specific instance. They didn't use the wetland everywhere. So you can't use the specific instance to overcome the general. The specific overcomes the general, but you can't use the specific to define the general. So as far as the specific goes, of course it overrules the general, but it doesn't read on the entire general, because then it would leave no general left. So that Congress used this specific definition in this specific section, does not read all sections. Let's Go Brandon says, do you use any leverage finance? I don't know what that means. Do you mean, do I like, do you mean like, do I do like a short or something on stocks where I'm shorting more money than I have? No. No, I don't use leverage in that sense. I don't spend any money I don't actually have, if that answers your question. You need a legal question on a transaction answered? Well, Let's Go Brandon, as I'm sure you well know, I can't give specific legal advice to individual people. So if you have a specific legal question, then I would recommend consulting a lawyer in your specific area. I don't do a specific individualized legal advice. I can refer you. Okay, send me an email to my address at Kurt@Uncivil Law LLC, and I'll see what I can do in terms of potentially referring you to somebody. The reference in the statute to adjacent wetlands wastelands must be harmonized with the phrase waters of the United States, which is an operative term that defines the Clear Water Act's reach. Because adjacent wetlands are included within waters of the United States, these wetlands must qualify as waters of the United States in their own right. That is, be indistinguishable as part of the body of water that itself constitutes waters. So indistinguishable, right? It is part of a contemporaneous, continuous whole. John Doe, I do interruptions on my videos all the time, and I edit them out. It's fine. I like to engage with chat, particularly when someone sends me a super chat. I like to engage with it. So I take breaks sometimes to talk about other things. It's fine. That's why we do edited videos. Okay. To hold otherwise would require implausibly concluding that Congress tucked an important expansion to the reach of the Clean Water Act into convoluted language in a relatively obscure provision that concerns a state permitting process. So again, it's just the specific is the specific and doesn't read on the general. That Congress in some specific part used the term wetlands, governs that part, but doesn't speak to the authority of the statute as a whole. $5 from Let's Go Brandon says it's complicated, just ignore that and do your show. Don't let me be a distraction. Just want to figure something out. I understand. And I appreciate your super chats, and I appreciate your support of the channel as a whole. In the past, you've been a very thoughtful contributor to the channel in the past, and I do appreciate your past contributions to the channel. They really have helped in a lot of ways. The channel currently undergoes about $400 a month of expenses, give or take, and I really appreciate your super chats in the past, and I really appreciate your financial support. It makes a big difference so that I can afford to keep going and also afford to eat. That's nice. I like those things. Incidentally, by the way, I'm thinking about doing a cooking stream later tonight. I'm thinking about making a casserole proper, baking a casserole. So we're going to do like an egg, sausage, ground beef casserole. And we're going to use like a dozen eggs, probably a dozen eggs, 1 pound of sausage, 1 pound of pork. And we're going to probably put in some onion and some bell pepper and some seasoning and cheddar cheese. And that should be pretty good. So that's kind of what I'm thinking about tonight. So good times. It's a more expensive meal than it was 2 years ago. Be that as it may, it's still less expensive than eating out all the time. It's also a lot healthier. So, and we will have some bell peppered. Bam. Oh, thank you. $100 from Let's Go Brandon. Well, make it happen instead of thinking about it. I'll email you. Thank you. I appreciate the super chat. That's very, very thoughtful. Thank you very much for your contribution. And I do try to make it happen. I try to make this channel happen. Last night, I did a little stream showing people the editing process behind the scenes, just to kind of show you the work it takes to put these things together. And I think people learned a lot more about how hash browns. So yeah, I don't really want to add carbs in. Yeah. Jeff says, I'd like to thank you. My daughter has listened to some of your streams on her mock trial Monday. Her team won the case, and she, according to her teacher, was the ethical backbone. Excellent. I'm glad I'm being a positive influence. That kicks ass. Mock trial also kicks ass. Recommended. Yeah. So just showing some people behind the scenes, right? And it takes, this stream is going on for at least 2 hours. It will take at least 2 hours to edit it. A little bit more, putting together the thumbnails and stuff and all the rest of it. And understanding the Clean Water Act to apply to wetlands that are distinguishable from otherwise covered waters of the United States would substantially broaden the statute to define navigatable waters as waters and adjacent wetlands, but the use of the term including makes it clear that it did not purport to do such a thing. It merely reflects Congress's assumption that certain wetlands are part of the waters of the United States, at least for some limited purposes. To determine whether a wetland is part of the adjacent waters of the United States, the court agrees with the plurality of use of waters. By the way, Let's Go Brandon. If there's something I can do on this channel to help encourage you to donate to the channel that doesn't require me taking just endless shots, I'd appreciate it. I don't really think it's healthy for me to just take the amount of shots that I have sometimes in the past as part of our streams, where we've done so many shots in the past. And so I don't really think it's healthy for me to do that anymore. But I did really appreciate your support. So if there's some way I can, encourage you to help support me without, just me destroying myself physically, I'd appreciate that. So that'd be great. I think the last time I did it in particular, it was really not good. I think it was a real problem. So, yeah. In sum, the relevant law extends only to wetlands that are, as a practical matter, indistinguishable from waters of the United States. This requires the party asserting jurisdiction to establish first, the adjacent body of water constitutes waters of the United States, which in and of itself is a relatively permanent body of water that's navigatable. So it doesn't necessarily need to be a river all the time, but most of the time in a relatively permanent way. So that it's a river one day a year won't cut it, presumably. And second, the wetland has a continuous surface connection with that water, making it difficult to determine where the one water ends and where it begins. So continuous is necessary. So great. You could always sponsor my workout streams if you like, or workout. I can't do a stream because I can't film from the gym, but you can always sponsor my workouts if you like. $100 a workout session. Yeah. Would that be good? Would that be good? I want to do 4 a week, ideally. If you'd like to sponsor my workout sessions at $100 each, that would be good. That'd be good for my health. It'd be good for the channel. You want to sponsor my workouts? That'd be nice. How about that? Every time I post a workout summary on my community tab, you give me $100. How about that? That'd be good. Let's see, where are we? The EPA asked the court to defer to its most recent rule, providing that adjacent wetlands are covered by the Clean Water Act if they possess a significant nexus, traditional navigatable waters. So we're back to the significant nexus test, but apparently what significant means is all the water everywhere. So yeah. You want me to give $400 a week to pump some iron? Well, not to put too fine a point on it. Let's go, Brandon. But when we were doing drinking streams, you were contributing at those kinds of numbers. So, I mean, I don't know if that's an undue ask, but I don't know. I mean, $100 a shot. We used to be doing those numbers quite heavily. So $100 a workout, where that would theoretically be like $1,600 a month if I do them all. I mean, that was sort of the numbers you had been doing. So it was a thought. Uh, oh, I already have a workout plan. I already have a coach to put together a workout plan. So I don't need a workout plan. I've already got that covered. Um, I'm using this app called Vault, and I'm using a virtual coach to help to put together a plan. So I don't need the plan. Um, but if you want to support what I'm doing, that'd be fine. An app? Yeah, it's an app called Volt. It's owned by Gatorade now. It was fairly common. It was fairly notable app for a lot of colleges in particular. Used it in earlier iterations before it became public. So it was initially used by a lot of colleges for their athletic problems, a lot of Division I schools in particular. And then Volt decided at some point to make it available to members of the general public. And it's a really well done app that really puts together a comprehensive exercise program. So I really, really like it. And then you can hire a coach to help you further by putting together specific workouts. So it's nice stuff. So you know, it works out pretty well. 6 days a week. I'm not sure I could do 6 days a week, Brandon. Um, if I do 4 days a week, I'm doing it every other day, which gives my muscles time to recover in between sessions. 6 days a week at the type of lifting I'm doing, I'm not sure that that's viable. Um, for my own physical health. But 4 days a week where I'm doing it every other day with the coaching is viable. It gives me a full day of rest in between to give my body some time to rest. I'm 42, I'm older. So also incidentally, see, I'm doing it wrong. Okay. Well, again, I mean, I'm put it together by a coach who has put together this schedule for me. And the coach himself seems to be well credentialed. And so yeah. So if you don't want to support that, I understand. Uh, I'm a little disheartened at the moment. I'm sorry. By saying I'm doing it wrong, that's disheartening. I know you probably didn't intend it to be disheartening, but it's a little bit disheartening. Um, it's better to do something than nothing. I'd appreciate your support of me trying to make steps in the right direction, even if it's not optimal. Um, I'm trying to do the right things. I'm trying to make progress. The app is called Volt, VOLT. Um, I need a minute. Sorry. I need a minute. All right. The EPA's interpretation is inconsistent with the Clean Water Act's text and structure and clashes with background principles of construction of texts that apply to interpretation of the relevant provisions. So the EPA's idea goes too far. First, the exceedingly clear language that's required if Congress wishes to alter the federal state balance or the government's power over private property is not present. So, yeah, Congress probably has the ability to do more in this domain if they want to, but they didn't, right? Congress does have authority when it comes to the waters of the United States. I mean, that much is clear. So they probably could pass more extensive statutes, but they didn't. House Bath says, don't be discouraged. Your health journey inspires me to take control of my own health. Thank you. I appreciate that. The court has thus required a clear statement from Congress when determining the scope of waters of the United States. Secondly, the EPA's interpretation gives rise to serious vagueness concerns in light of the Clean Water Act's criminal penalties, thus implicating due process requirements with respect to penal statutes with sufficient definiteness that ordinary people can understand them. So if we interpreted it this far, we would have problems in the criminal context because we don't want statutes to be unduly vague. And this statute, if interpreted this way, would sweep in so much power that it is not really what is within the con. So the idea of the rule of lenity as an idea, reading a criminal statute more narrowly, also suggests this result. When a penal statute could sweep in enough criminal conduct of a host might would where a penal statute could sweep in enough conduct to render a criminal a host of might what otherwise be ordinary activity, the court has been wary about going beyond what Congress clearly intended the statute to cover. Under these two principles, the judicial task of interpreting the waters of the United States is to ascertain the clear congressional authorization that exists to make sure that we're not sweeping in more conduct than Congress wrote about. What is rule of lenity? It's a rule of mercy, basically, leniency. Rule of lenity, same root word as leniency. To interpret a criminal statute in a lenient way. The EPA claims that the Congress ratified the regulatory definition of adjacent when it amended the Clean Water Act to include reference to adjacent wetlands in the relevant statute. So one of the things we're going to try is that this had been the policy of the EPA, and we think that Congress adopted our meaning when it amended the statute. So let's try that. This argument fails for at least three reasons. First, the text of the relevant law shows that adjacent cannot include wetlands that are merely nearby covered waters. Second, the EPA's argument cannot be reconciled with its court's repeated recognition. The relevant statute does not conclusively determine the construction to be placed on the relevant definition of navigatable waters. $10 from Let's Go Brandon. That wasn't an insult or anything negative. I can with the training at all. I can bench over 300 pounds and my strength training coach ran a 40. Backwards faster than Michael Strang Ford. No, I don't doubt your intentions, Let's Go Brandon. I know you are a good guy. You have been a supporter of the channel. I understood that your comments were not intended negatively. This is more on me than it's on you. I understood that. Right? This is more on me than it's on you. Okay? In this particular instance. All right? This is on me. My reaction to your comment was not really warranted by your comment. My emotional reaction was more strong than your comment warranted, but I recognize that it was, right? And so, the fact that I take a second for myself is more on me than you. As I've discussed many times, I suffer from depressive disorder, okay? And sometimes because of that, things hit me a particular way, but I recognize that that's happening, right? So this is more on me than it's on you. It's my failing. It's part of my failures or part of my weaknesses as a human being. And I recognize that. I understood that you were coming from a good place. But I'm just trying to say that I think I'm pursuing a path that makes sense. I understand and appreciate that you very well might be able to help me put together something that might work. But I already have something that I think is working, and I'd like to continue pursuing this path for the moment. I have some confidence in the app. I have some confidence in my coach. They have put together something that makes sense for me that I enjoy doing. And so I'd like to continue pursuing that. So, when you said I was doing it the wrong way, that hit me just a little bit hard because I perceived it as me saying that I'm a failure or I'm failing. And I'm like, but I'm really trying and I'm trying to do the right things. And I think that this makes sense. And if you'd like to get behind me and support me, I'd really appreciate it. And if not, I understand, but you used to give me money for shots. And I was like, what if you did money for me doing something that is more healthy for me, backing me that way. And then maybe that would be a way to, do it. It was just an idea, man. And I appreciate that you've been there for the past. And if you never give me another dollar in your life, that's okay. You're under no obligation to give me money. No one's under obligation to give me money. If you never give me another dollar again, I understand. It's fine. Maybe for whatever reason I'm not the creator for you. Maybe I'm not doing it the way that you like or whatever. I'm doing the best that I can. I'm being the best creator I know how to be. I'm doing this as best as I know how while being true to myself and dealing with my own issues and dealing with my own problems. And I'm overweight and I don't eat right. And I'm trying to solve these problems. I'm trying to do the best I can. And, every single day I try to do stuff for myself and for this channel. And I do the streams because I'm trying to make myself better as a creator. I'm trying to make myself better as a presenter. I'm trying to figure out how to do this. I'm trying to figure out how to make this succeed. And I'm doing the best I know how to do. So yeah. All right. The EPA claims that Congress ratified its interpretation of amended when it included the reference. The argument fails for at least 3 reasons. First, the relevant text shows that adjacent cannot include wetlands that are merely nearby covered waters. Second, the EPA's argument cannot be reconciled with its court's repeated recognition the relevant statute does not conclusively determine the construction to be placed on a relevant definition of navigatable waters. Okay. Third, the EPA falls short of establishing the sort of overwhelming evidence of the acquisitions necessary to support its argument in the face of Congress's failure to amend a different section of the statute, which is more relevant here. Finally, the EPA's various policy arguments about the ecological consequences of narrow definition are rejected because, well, maybe that's true, maybe not. But of course, what we do is statutes, and that's not what Congress did. Alito delivers the opinion of the court in which Roberts, Thomas, Gorsuch, and Barrett join. Thomas files a concurring, Kagan files a concurring, which Sotomayor and Jackson join. Kagan files an opinion concurring. So this is a unanimous Supreme Court, although they differ a little bit about the reasons. So they all agree, but for different reasons. So that's pretty cool. Yeah, $10 from Let's Go Brandon. Kurt, I can't be everywhere as once just to throw money around. I remember exactly where you were when you unveiled the 100,000 plaque. I was walking my dog. You're awesome. That's cool, Brandon. That's cool. I understand. I totally get it. You have your own needs. You have your own desires. I don't know your situation. I don't know what's going on in your life. I don't know what you need or what you don't need. I am not entitled to your money. I wasn't trying to imply that I was entitled to your money. I understand that you have needs and wants and desires and all the rest of it. And If you can't throw money around either to me or in general like you used to, then I totally understand. I'm not trying to guilt you, man. I'm not. I'm not entitled to anything. You know, maybe entitled to a like at best, you know, or entitled to if I'm not really entitled to even that much, really. I'm not really entitled to very much, except, you know, some courtesy in my own channel, which I insist on. You know, I insist on people being, you know, at least polite. So I'm entitled to some basic human courtesy. That's about it as far as entitlement goes. I'm not entitled to your money. I'm not entitled to your love. Um, if you know you have your own needs and your own wants and your own desires, and I totally get it. I totally understand it. If you don't want to do it, if you can't do it, if you're not interested in doing it, if whatever, you know, your reasons are your own, that's totally fine. I get it. I wish you nothing but the best. I appreciate your support in the past, and I hope whatever situations you're dealing with in your own life will be resolved as we're all trying to struggle through this, you know, as we can. I know you're polite. Let's go, Brandon. I wasn't trying to imply you're not polite. I wasn't trying to imply you're not polite. I wasn't trying to say that. I wasn't trying to say that at all. I know you're not provoking. I wasn't saying you were. Am I not being clear? I'm trying to be clear. I know you're polite. I know you're not provoking. You're a good guy. It's fine. I know you're not. I know you don't have any. I know you don't have any ill intentions. I'm not trying to accuse you of ill intentions. I'm not trying to accuse you of being impolite. I'm just trying to make clear that I don't think I'm entitled to anything. I was just trying to make clear I don't think I'm entitled. That was all I was trying to do. And then be like, well, okay, maybe entitled to one thing, some basic courtesy. But I wasn't trying to imply by saying that you weren't showing me basic courtesy. That wasn't my implication. I was just trying to make clear I don't think I'm entitled to anything beyond that. But you give me that. You're fine. It's all fine. You know, you know, I'm not trying to make you feel bad. I'm really not. I'm not trying to make you feel bad. I'm not trying to make you feel guilty. I'm not trying to make you feel anything. You know, I'm not trying to make you feel unappreciated. I'm not trying to make you feel like what you've done in the past isn't enough. You're a good guy. I don't I'm just trying to do my best over here. I'm not killing my show for you, Brandon. I have other things to talk about. But you're more than welcome to DM me if you like. Thus, that brings us to the end of this case about the EPA, where their powers get a little bit lighter. So the EPA no longer has the ability to regulate all the water everywhere. They have the ability to regulate the navigatable waters of the United States and the waters which are indistinguishable from the waters of the United States because they readily flow and are continuous with the flows of the United States, but not whatever this is. Because the guys are across from a ditch that flows into a stream that flows into a lake, not so much. That is not the waters of the United States, nor incidentally does it seem like the ditch or the stream is, incidentally, by the way, because they don't qualify as navigatable waters onto their own right. So the EPA power gets a little bit less. And the details, of course, will matter, as I'm sure the EPA will continue to try to expand its power to the limit. But those, you know, most outrageous excesses, at least for the moment, are barred. And that brings us to the end of discussion of this case. You had a date like this one where you just kept misunderstanding each other? Yeah. Yeah, that sometimes happens. That can be frustrating. Yeah. Am I doing improv? Yes, I do it every Monday. I do improv on Mondays. and I really enjoy it. It makes me happy. Excuse me 1 second. All right, great. Okay. 1 second. All right. Push the button. The time is glorious time for you and me. You and me. I'm a grown-ass man and also losing my shit right now over lack of spelling. I didn't comment on your spelling. When did I comment on your spelling? I just don't understand. I just don't understand. All right. Let's see what else we got. All right, let's cover this one. Can I show you the video I sent earlier? Oh, no, I don't. No, I don't think so. Did I push the button? If not, I'll push it again. It doesn't matter. All right. All right. In immigration law, the state of Texas has passed a law to try to give its own state level authority power to enforce immigration law, which will undoubtedly come under challenge from the federal government because the federal government has the exclusive power to deal with immigration. So states do generally have power of law enforcement, but in immigration specifically, not so much because the Constitution gives it exclusive power. So when you have state level authority trying to enforce immigration law, in a way that this federal law does not explicitly authorize, because of course the federal law might give power to the states in specific instances. So to the extent that's true, that would be fine. But otherwise, you run into a problem because this is by federal law, the Constitution, an exclusively federal domain. But Texas is trying to reach into this domain. So let's learn a little bit more about what's going on. A sweeping border security bill that critics say would empower Texas law enforcement to enforce immigration law has passed the Senate. The bill would create a state crime of improper entry from a foreign national. Not so sure about that one. And establish a border enforcement unit that would permanently be deployed. Also, not so sure about that one. Not sure about any of that. That sounds problematic under the US Constitution. The measure received approval from the Senate along party lines. The bill heads back to the House, where it will need to accept changes or negotiate a compromise before it heads to the governor. Democratic senators took aim at how the bill would authorize officers of a Texas border force to arrest migrants who enter Texas illegally. They argue, and probably quite properly, to be honest, that encroaches on the federal government's responsibility to enforce immigration law. Yeah, I mean, that's what the Constitution seems to say. The Constitution seems to say that the federal government is the one that gets to enforce immigration policy, which of course makes sense from first principles, because who gets to enter a border of any description is one of the fundamental aspects of what countries are, right? The right to have a border and control it is in the nature of what it means to be a nation from first principles. The permanent population, a permanent geography, the right to have a border and control it. These are sort of the fundamental aspects of what countries are. So if anyone has the power to do this, it's the federal government. So Texas getting into it has a problem. If the bill becomes law as expected, it would face a challenge in court. I would think so. Under a 2012 United States Supreme Court decision, states cannot encroach on the federal government's job to enforce immigration because, again, U.S. Constitution, that's what it says. The Texas Attorney General told lawmakers in previous months he'd like to challenge the precedent. Okay, so we are passing the law with direct knowledge that we are trying to go against the federal law, but we're doing it with the intention of creating standing for ourselves to get to the U.S. Supreme Court because we'd like to overturn the law. Okay, I mean, states do that sometimes, right? We deliberately and somewhat intentionally are passing a law that is unconstitutional in order to challenge the very constitutionality of the decision. So not unprecedented in this respect, but the constitutional text is kind of clear on this point. So I'm not really sure how we're going to challenge the precedent, because what are we challenging it on? Because the text of the Constitution seems somewhat clear. So yeah. Democratic senator says we can use different terminology, but the reality is we're enforcing immigration law. Yeah, again, as always, what we put on the label is not necessarily what's going to come to the attentions of the courts, because we're not that dumb. We won't call it immigration enforcement. We'll call it Ensuring Texas Solidity Act or something. I don't know. But yeah, if what you're really doing is the immigration authority, we don't really care what you call it. We don't care what you put it on the label. Courts are not this dumb. A Senate author disagreed with this by saying if individuals obey the law as we passed it here, and they go to ports of entry, immigration services, and border patrol, they'll issue that individual to apply for asylum. Well, that is already the U.S. law, incidentally. If you want to get asylum by law, what you're supposed to do is go to a port of entry and apply for asylum there. That's already U.S. law. So you're not supposed to enter the country illegally in order to apply for asylum. You're supposed to go to a port of entry and apply for it there. But Texas wants to do this as a matter of state law, and no. Under the proposed law, a migrant who enters Texas would be charged with a Class A misdemeanor, which would carry a penalty of up to a year in jail and $4,000 fine, which could escalate to a felony. No, this is illegal. You can't do this. I understand Texas as a Texan. I totally get it. I totally understand how frustrated you are and how mad you are at the federal government for not enforcing our border law. As a Texan, I understand how much this hurts our state in particular, and how much our state in particular has to bear this problem. I get it because of how big our border is with Mexico. Kind of notable that this would impact Texas somewhat. I totally understand your frustration. I get it. But, and I would like the US government to enforce its immigration law a lot more. I really, really would. As a conservative, I'd like them to do that. But as a conservative, I also have to interpret the Constitution as it's written. And the Constitution as it's written gives this to the federal government. So the federal government effing this up is really, really annoying. But unfortunately, it's theirs to F up. So I don't know, sue the federal government for not enforcing its law better if you can find a way to do that. Or something else, but this isn't going to work. And you're not going to get the precedent overturned because the Constitution is directly on text against you. It's not ambiguous. Uncivil laws, justice would have no choice to continue enforcing this law the way it is, because it's what you're trying to do is illegal and the precedent is legally correct. So, no. The newly drafted House proposal on top of the Senate bill would create a 10-year prison sentence for human smugglers. and forbid local municipalities from limiting authority or jurisdiction of the unit, which that much at least is constitutional, right? State controlling state level authority. That part is constitutional. So the state saying, local municipalities, you do not have any power to restrict or interfere with our state level authority. That part is constitutional, right? You can't stop our state level authority from doing its state level thing within the state. That part is fine. Not so much with the federal law, though. The new border unit would be housed under Texas Rangers. He would report to the Department of Public Safety. The proposal would drastically change Texas border security operations, which has been a priority. Operation Lone Star is stretching into its third year and has already cost the state at least $4.6 billion. It's consisted of rotating soldiers from Texas National Guard. Members of the new force would be permitted to be stationed in the region. Abbott has largely not commented on this. At a news conference, Abbott said Texas has the right to secure its border and blamed the federal government for being too lax. Well, some of that is definitely true, but you have the right to secure your border. Actually, not so much, because you're not a country. So, no. The bill drew outrage from Democrats, immigration rights advocates, and civil rights unit groups who said it would create a vigilante unit, which to some degree, I suppose it does, because it's outside of lawful authority, because it's unconstitutional. So I suppose it is a bit of a vigilante unit in that respect. While laying out the House bill, a senator said there were several problems in it when it was received from the House, particularly with the structure of the unit and chain of command, which, okay, I mean, fine. I really take no particular position on how the unit is structured or its chain of command or who it should report to or what authority it has with respect to localities. I don't know and don't particularly care. As to that much, the state can do what it wants. So sure, the chain of command is a problem. Fine, maybe it is. That's, have it report to whomever you want to. It's not going to solve the problem, the fundamental problem. Senators made additional changes, including one by a senator specifying that only, licensed police officers would be able to arrest migrants and carry weapons. People who are not police officers could only act in support, but not do that. Well, okay, fine. I mean, so no citizen's arrest for the unlawful immigrants, which, yeah, okay, fine. After the final Senate action, the House can accept that or modify it. The deadline is on Friday. Do cartel traffickers enter the state? I bet you they do. I bet you they do enter the state. Yeah. When did Texas actually agree they aren't a country? Oh, that's actually pretty interesting. The Texas actively, very actively advocated for their statehood in the first place. Since Texas actually had an ambassador's office in DC in its early history. For like the 8 years it was a country or something, between coming out of Mexico and becoming a state. It actually had an ambassador in DC, and Texas very actively petitioned for its statehood during that period. So yeah, as to that much, you don't have any problem. Texas very, very much wanted to be a state, including by appointing an ambassador, which I think is a cool little touch. I'm not sure any other state did that. I mean, I couldn't swear to it, but I'm not sure any other state ever did that, but Texas did, which is kind of cool. Thus, that brings us to the end of discovery of this case. Well, excuse me. Thus, that includes the end of discussion of this case of Texas trying to enforce national law when it comes to the border, which, no, not so much. It might be a good idea to enforce the border. In fact, I really think it is. I think we're a country of laws, and our laws include the right to have a border, which is part of the fundamental definition of a country. It is fundamentally part of a country, the right to control your border and what comes through it. You can decide nothing comes through your border of any description if you want. That's part of the nature of a country. Or, of course, you can decide to not do that. You can decide to like have trade with other countries, and which countries you have trade with, of course, is your discretion or not. So you can just go maximum isolist if you want, or you can go somewhere in between. The United States, of course, has gone somewhere in between, but we do have immigration laws, which are not being well enforced by the United States federal government. Texas would like to get involved. Unfortunately, the federal government has not authorized this. They could authorize state level authority to help enforce the law. So that might be one way to go about it, but they haven't done that. And so Texas wants to do it unilaterally, and no, not so much. So this proposal looks very unconstitutional, and I imagine will be struck down. They want to try to get to the US Supreme Court to overturn the precedent, but there's no reason to overturn the precedent because the Constitution seems very clear on this point. So I don't think the justices are going to go for it. So no. But we'll see how that all goes. And that, for the moment, brings us end of discussion of this case. Taxpayer must render under Caesar what Caesar's, but no more. That's good. I like that line. That's a good line. That's a good line. Did we not pull up a Florida man story today? I don't think I did. What's going on in Florida man news? Push the button. Thank you. Time is glorious time for you and me. You and me. Soup time is glorious time for you and me, baby. Soup time is glorious time for you and me. Soup time is glorious time for you and me. Okay. Is there more information on this story? Yeah. All right. That's a good Florida man story. We'll do that one today. Uh-huh. Okay, that's a good Florida man story today. That's pretty dumb. All right, we have one more Supreme Court case today, and I do want to cover that. And then I had like 8 other stories. Is there anything in here that I really want to cover today? Let's see. Let's cover the Supreme Court case and then let's do Florida man. Does that make me the soup dragon? Sure. I'm the soup dragon. Why not? I'm the soup dragon. That sounds good. I like being the soup dragon. All right, let's discuss. All right, let's see what's going on here. Okay. Okay. Let's see what's going on. Okay. For today's case, we cover a situation in which a prisoner claims that a correctional officer got other correctional officers to beat him up while he was in custody, and he claims, therefore, excessive use of force in violation of law. This turns on an administrative issue to determine whether or not the prisoner properly preserved his rights to bring the issue, and what administrative remedies he had to seek and how to go about seeking them before he could go to court. So let's learn a little bit more about the issue, how the prisoner brought the litigation, and whether the prisoner forfeited his rights by improperly bringing the litigation or making a mistake along the way. Let's get started with this. The respondent claims that during a pre-trial detention period, while he was in Maryland State Prison, the petitioner, who was a correctional officer lieutenant, ordered 3 other guards to attack him, and therefore sues for damages under 1983 to alleging excess force. So it's not because he was misbehaving. It's not because we need to gain control of him. We're basically doing it for some sort of form of revenge, which, not so much. You can't do that. You do have an affirmative duty in this situation, by the way, as a police officer or a correctional guard, because he's in custody. So first of all, you couldn't do it in any event. Second of all, you do actually have an affirmative duty in the situation because he's in state custody. And so, that violates that as well. Prior to trial, the relevant guy, the petitioner, the correctional officer, moved for summary judgment under a relevant federal rule, arguing the prisoner had failed to exhaust administrative remedies. So we think that, you might have a claim, but you didn't do exhaustive administrative remedies. Now, incidentally, this is in state level law, which doesn't necessarily, as a matter of state law, require exhaustion of remedies. If this were federal, then yes, we have to exhaust remedies first. But state law, it depends on how the state law is written. So they're saying you didn't exhaust administrative remedies and our state requires you to. Okay. The relevant rule requires a district court to enter a judgment on a claim if there's no genuine issue of fact and they're entitled to judgment as a matter of law. So if it's true that you had to exhaust administrative remedies first, and if it's true that you didn't do that, then yes, judgment as a matter of law, right? There's not an issue of fact. It's an issue of law. You just didn't go about it right. Go talk to the administrative agency first, then maybe talk to me. You missed a step along the way. The district court denied the motion, finding no dispute that Maryland's prison system had internally investigated the assault and concluding this inquiry satisfied the obligation. So the district court says, well, if he does have an obligation to exhaust administrative remedies, he has done that. He's already done that, and now he's here. So I don't even know what you're complaining about. He's already done the administrative thing, so he's in the right place, assuming he had the obligation in the first place. Great. At trial, the individual did not present evidence relating to the exhaustion defense. So he had said, I can't be brought here because you didn't exhaust administrative remedies. He brought that as a matter of law. The district court ruled against him. At trial, he didn't offer any evidence about that. So he didn't say, well, here's evidence about that. He didn't offer any evidence along those lines to say, the administrative remedies that did or did not take place. The jury found the defendants liable for $700,000 in damages. So pretty bad beating, I guess, of a prisoner. So yeah, these 4 guys conspired against him to beat him up. They did beat him up. $700,000 in damages. The individual, the lieutenant who had ordered this, did not file a post-trial motion, which would have allowed a disappointed party to file a renewed judgment for judgment as a matter of law. So you can also, of course, ask for a judgment as a matter of law at the end of a case. You ask for it at summary judgment, and you can also ask for it at the end of the case as well. A judgment notwithstanding the verdict, right? So the verdict is, how about guilty or how about liable? So technically speaking, there is a slight difference between a judgment notwithstanding the verdict and a judgment as a matter of law, right? So a judgment notwithstanding the verdict would be the court saying, okay, I think based on the evidence, not guilty or not liable. I disagree with the jury. That's a judgment notwithstanding the verdict, right? The jury returns a verdict, but only the court enters judgment. There is a legal distinction between a verdict and a judgment. Juries do verdicts. Courts do judgment. So a judgment consistent with the verdict would be guilty or liable. How about guilty or liable, as the case would be? That would be consistent. But a judgment, notwithstanding the verdict is guilty or liable. How about not guilty or not liable? I don't know what evidence you were looking at, jury. I don't know what evidence you were looking at, but this is clearly not guilty. I don't know what you're doing. All right, a judgment as a matter of law is technically different because it's like, upon further consideration, upon renewed consideration, it was legally impossible. It's not that the jury made a mistake. It was legally impossible for them to do this. I should have filed that. I should have given that summary judgment. I don't know what I was thinking of, and I should have really done that in the first instance. I'm so sorry. My bad, but I can fix it now by giving a judgment as a matter of law. So, but he didn't ask for that. He didn't ask for his renewed judgment in law. He didn't ask the district court to, have you reconsidered that whole thing from the first start, that you should have granted that motion of summary judgment long, long ago? Have you reconsidered maybe doing that now? Didn't ask. So he appeals to the Fourth Circuit on the rejection of exhaustion defense. Did he preserve his issue? Did he preserve it? Well, he asked for a motion for summary judgment, but he didn't bring any evidence at trial, and he didn't ask for a renewed motion at the end. So did he preserve his issue? Can he do that? The Fourth Circuit, bound by precedent, which holds that any claim or defense rejected at summary judgment is not preserved for appellate review unless it's renewed, dismisses. So do you have to renew it or not? The Fourth Circuit says you do have to renew it in order to preserve it. So do you have to renew that objection? Do you have to renew that motion? This is incidentally one of the reasons that lawyers do all these renewals and keep asking and keep re-asking, because they want to make absolutely sure they preserve the issue. This guy, for whatever reason, didn't do that. So is his failure to do that a problem? Do you have to file the motion in order to preserve the issue? The Supreme Court says the post-trial motion under Rule 50 is not required to preserve review on a pure legal issue that's resolved at summary judgment. So no, you didn't have to bring the motion. This is a pure issue of law. The facts are completely irrelevant to this issue. It's a pure issue of law. So you brought it up at the summary judgment. You didn't have to renew it. You could have, but you didn't have to. So fine. In a relevant case, the court has held an order denying summary judgment on sufficient of evidence grounds is not appealable after trial. So in a prior case, we dealt with sufficiency of evidence. Is there enough evidence? In other words, judgment notwithstanding the verdict, for example. So can you appeal that? Because that's factual in nature. Because a factual record developed at trial supersedes the record established as a summary judgment, it follows a party must raise the motion again, which makes sense, right? So if you're going to get a judgment right off the bat, it's called a summary judgment for a reason. It is a judgment, right? It is a conclusion. If you're going to get a summary judgment on the facts or on the issue as it's presented at the case, right? The amount of facts that are known at that time is obviously different than it's going to be known at trial because we haven't done discovery yet, right? It's a process that comes before discovery. It's based purely on the papers of the person who is filing it, right? These are my allegations of my facts. This is what I believe to be factually true. And a summary judgment is all about, even if those facts are true, you still lose, right? It assumes the facts are true and says, even if those are true, you still lose anyway. You don't have a case, you have no case. Well, what if we say, okay, if the facts are true, you do have a case? Well, as the case progresses and as we do discovery and as things go on, maybe those facts turn out to not be so true, right? Maybe the evidence, as it's actually revealed along the way, shows the plaintiff's claim to be a little bit more hypothetical than real. And right, and we can even do this as far as the end of the trial, if we got that far. Maybe we'll leave it to the jury, because if they come to the right conclusion, I can avoid this problem completely. So I'm just going to hope the jury solves this problem. But ultimately, the jury came to the wrong conclusion. So now I have to fix this mess. So it's like, okay, as it turns out, your facts are BS. You'd had nothing. I don't know how the jury possibly came to this conclusion. Or, as we now know the facts, it's a matter of law. So the jury screwed it up. They weighed the facts wrong. Or the facts as they actually were revealed at trial, as opposed to the hypothetical facts you wished were true. The real facts that were revealed at trial, you never had a case. So basically, you lied to us in the first case. You lied to us in the first instance. in that motion. So, we're going to fix that now, and also be thinking about sanctions possibly against the attorney for potentially lying to the court because you fronted that you had things you never had. So we're also thinking about maybe this is sanctionable conduct at this point as well, too. So if it's a motion for summary judgment based on facts, the facts have changed. So obviously you have to renew that because, well, the facts have changed. So the same is not true for a pure issue of law because the facts don't matter and never did matter. The facts are irrelevant. We can decide this on the law. It doesn't matter. So the whole jury thing was a bit So we can decide this. So there was nothing new for the court to do here, because it's a pure issue of law. The conclusions are not superseded by later developments in litigation, and the rulings merge into the final judgment, at which point they are reviewable. So this case was never cognizable in the first place. Okay, the issue is preserved. The reviewing court does not benefit from having a district court re-examine a purely legal ruling because nothing at trial will give a court any reason to question its own prior analysis. Well, I don't know if that's strictly true. That won't give them any basis to re-examine because the court may have thought better of it based on what happened at trial. But, okay, it's true enough. It's true enough, right? It's a pure issue of law. You could have found this way in the first instance. So, there's nothing should have happened that should cause you to re-examine it. That's probably better. Nothing should have happened that should have caused you to re-examine it because it's a pure issue of law. So, but of course in the real world, maybe sometimes, but we'll pretend it never happens. The counter arguments are unpersuasive. The relevant law does not hold that any order denying summary judgment is unreviewable. While an interlocutory order, which is where we appeal while the trial is still happening, denying summary judgment is not typically appealable. So, you can't appeal the denial of summary judgment. That's not one of those appealable things. Please continue at your trial. The relevant law does not insulate interlocutory orders from appellate scrutiny, but rather delays their review. So it's not that you can't appeal, it's that you can't appeal now, right? So, no, you cannot appeal while the trial is still ongoing about your summary judgment. But you can appeal at the end of the trial, which maybe is a little late, but, well, that's the rule, right? So, wait till the end of trial. Yeah, you should have won off the first of the bat. But you can't appeal until the end, but you can appeal at the end. And while the guy insists that there should be a no two-track system of summary judgment, with factual claims and legal claims follow different rules, that doesn't make sense. Right? There is a two-track rule. If it's facts, the facts change. So, renew your motion. If it's law, it's not necessary, but you really should do it anyway as an attorney. By the way, as an attorney, I would not recommend not doing this. Just file the thing, even if it's a little bit, duplicative, because why not? Why take the chance? But okay. On the contrary, fitting the preservation rule to the rationale underlying summary judgment is consistent with the rule, which of course makes logical sense. Factual development at trial will not change the district court's pretrial answer to pure law. Well, at least it shouldn't hypothetically. Shouldn't do that, but yeah. So a post-trial motion would amount to an empty exercise. That should be true. Finally, while the guy predicts that a separate preservation rule for legal issues will prove unworkable because the line between fact and law can be vexing, the relevant case law demonstrates that they overstate the problem. Courts of appeal have long found it possible to separate factual from legal. Also, by the way, don't even try. Don't even try. Why try? Why try to separate the issues if you're an attorney? Just bring them both. Why even try? There's nothing requiring you to try. Just bring the motion. Right? Is it a fact or is it law? Why even ask the question? Just bring the motion anyway. It'll solve that problem right up. Then you don't have to worry about it. Why even try? That's beyond me. But if you're going to try, courts can figure it out. So if you want to, figure it out, we can figure it out. But why bother? I don't know. Courts of appeal have long found it possible to separate factual from legal. And the Court of Appeals for the Federal Circuit in particular has a bit of a problem with that, by the way, with the mixed questions of fact and law. So I'm not sure that necessarily is true. But then again, the Court of Appeals for the Federal Circuit deals with patent law, which might be in its own little special universe, but we'll pretend that the courts of appeal can do this. which I'm not sure is universally true, but let's pretend. Here, the court does not decide the issue raised on appeal is purely legal and remands to the question in the first instance. So we're not even deciding whether or not this is a pure legal issue. If it is, though, it's preserved. But Fourth Circuit, you can figure out whether it's a pure legal issue or not. That should be fun. Vacated and remanded by a unanimous Supreme Court. Thus, that brings us to the end of the case dealing with the prisoner. Sorry, that's the wrong guy. Thus, that deals us with the end of the case of the prison official who ordered a guy beaten up. And the guy won $700,000 a trial. How nice for him. The guy says, you can't bring a lawsuit against me because you didn't exhaust your administrative appeals. The district court disagreed, saying, yes, you did. He exhausted administrative appeals, but that's a pure legal issue. Whether he exhausted, first of all, is it required to do that, which is a matter of state law. So first of all, is he required at all to exhaust his administrative remedies is a question of law that depends on Maryland specific law. So that's question number one. And question number two, assuming he is required, did he actually do that? Which is also a question of law, right? It's not dependent on the thing. And the prison guard says, well, I properly preserved my issue. And the Supreme Court says, maybe you did. Maybe you did because you didn't raise the issue. But if it's a pure issue of law, sure, you preserved it. So go ask the Fourth Circuit about whether or not this is a pure issue of law or not. And figure that out. And then also, assuming it is a pure issue of law, then of course, that only entitles the Fourth Circuit to decide the issue and determine whether the district court was right or not. So even assuming it is a pure issue of law, it doesn't mean the Fourth Circuit was wrong. Or it doesn't mean the district court was wrong. So the whole thing might be a little bit moot, but that's okay. We do it the hard way. And that for the moment brings us to the end of discussion of this case. Fantastic. Hey, Sean, how are you doing? I'm glad you're here. Oh, I'm glad you enjoyed my stream today, Lemon Drop. I'm glad it was good for you. I'm sorry for my failings as a person in every possible domain of failure. I love you all. I appreciate your support. I appreciate your love. You guys are great. You missed earlier discussion, John. It's not important. It's not important. Okay. Moving on. I don't have OCD, but I do have major depressive disorder. Yeah. All right, let's do Florida Man. I'm hungry too. So time for cooking this evening? I don't know. I need to order stuff. I need to go to the gym. I need to eat. I need to eat. I need to go to the gym. I didn't work out yesterday and I really wanted to. It's also made me feel like a bit of a failure. I really wanted to work out yesterday and I didn't. So I think the workout discussion in particular hit me a little bit hard because I had really, really wanted to go to the gym yesterday and I just never did. And so I was already feeling like a little bit guilty over the whole thing because I wasn't meeting my own workout goals. And so I think the discussion hit me particularly hard. So, anyways. In Florida Man news, Florida Man is traveling through the great Commonwealth of Virginia on his way to the CIA. He would like to visit the CIA in Langley. He has some thoughts he would like to share with the CIA in Langley. Along the way, he decided to go trespass at a Virginia daycare, which I guess he thought might be affiliated with the CIA in Langley. And an AK-47 was found in his car. Florida Man may not be doing very well in the mental health domain. Let's learn a little bit more about Florida Man. A man was arrested in a Virginia daycare in Fairfax County, a county I know very well because it's a place I lived for 15 years. Near Alexandria. I think at one point I technically lived in Alexandria City, but basically Fairfax County. I know the county very well. I know neighboring counties very well. It used to be my home. So this is all happening there. This is great. In a series of tweets, the police department say the suspect is Florida Man, 32-year-old Eric Sandeau. He was seen trespassing at the Madison Preschool in McLean, which, you know, is where the CIA is. Yeah, that's where the CIA is. McLean, Virginia. Yeah, that's where it is. He apparently was stopping by the daycare on his way to the CIA. Maybe he was trying to find a kid of a CIA official who he could use to badge in the facilities. I don't know. The preschool, of course, being in McLean, is just a few minutes away from the CIA building, which is in Langley, which is McLean. So, yeah, that's where the CIA is. Officers detained the guy and executed a search warrant where they found 2 firearms, including an AK-47. He's been charged with felony possession of firearm on a school property. I don't know about that in terms of the law on that issue or not, but okay. The incident comes after another suspect was arrested in the area after wielding a metal baseball bat and attacking 2 members of Congress. That incident occurred at the office in Northern Virginia, and the suspect was attacked, and that attack was identified as Fairfax Man. He faces charges, that guy faces charges of malicious wounding and aggravated malicious wounding. In nearby Washington, D.C., another suspect crashed a U-Haul into security barriers across from the White House. Yeah, we missed that story. We didn't cover that. A guy took his U-Haul and decided to crash into the fence at the White House, which, you know, unsurprisingly is designed to withstand U-Haul related driving incidences. The driver of the truck, who apparently had a Nazi flag, was identified as 19-year-old of Missouri, according to court documents. He's been charged with 1 count of deprivation of property of the United States, and I also think might have been charged as well with threatening the life of the President of the United States. So, good times. Things are going great over here. Plus, that brings us to the end of the story of Florida Man, who apparently joined some other people from Missouri and other jurisdictions in, you know, doing some things in the Northern Virginia area. Florida Man on a trip to see the CIA and stops by McLean, which is where the CIA is. That's Langley. That's where the CIA is. That's certainly where they're located, and stops by a daycare. Unclear if he was trying to find a child of a CIA worker, maybe threaten them or something. I don't know, but he has some words for the CIA and apparently words for the daycare, and has been arrested, facing charges for the possession of the firearm on the school property. And I imagine other charges will be coming down the line as well. So we'll see how that all goes as things progress. But that, for the moment, brings us to the end of discussion of this case. Yay. A guy tried to crash in the barriers of Downing Street. Yeah, that's probably not going to work. I imagine it's been fortified against, truck attack. It's not that hard. You get yourself some bollards and you're good to go, And they make nice looking ones. So. Maybe he thought the preschool was the CIA. I didn't think about that possibility. Yeah, maybe the CIA, maybe the preschool is the CIA. It's all a front. Maybe the children are CIA operatives. Does the CIA employ children? I wouldn't put it past them. Does the CIA have an indoctrination facility in Northern Virginia? What kind of lessons are they teaching the children in the preschool? A is for apple, B is for banana, C is for censorship, D is for detention, E is for espionage. F is for FOIA, which we don't like. G is for G-Man, our hero. H is for hidden. I is for incognito. N is for no such agency. The entire NSA was classified for a while. I'm not sure how many people know that about NSA history, but the entire NSA, the entire goddamn agency, was classified for a hot minute there as federal law. The mere fact they existed. Yeah. J is not for justice, whatever J is for. You need to try again on that one. Z is for zebra, which is a code name for our secret exercise. P is for police action. Police action, when it comes to the CIA, has a slightly different meaning than it does to your standard law enforcement officer. When we say police action when it comes to our friendly neighborhood cop, and we say police action when it comes to the CIA, these have slightly different meanings. W is for wet work. Eh? Eh? Should write a kid's book? Maybe. I could do a whole series of books, kids' books about governmental agencies. That'd be good. My first book about the FDIC, my first book about whatever. Do it as alphabet books. Maybe there's something in there. Maybe I should go to a publisher and do a spec idea. Maybe there's something in that. T is for torture. Yeah, it could be good. All right. All right. I'm going to go to the gym now and get my workout on because I didn't yesterday and I really want to, and I want to today. So I'm going to get my workout on and then I'll post the results, of course, on there. And then I got to edit this. And then I got to post things for tomorrow and then maybe some Zelda at some point as well. Oh, gifted memberships. Thank you for reminding me, Sandra. I'm off in my own little world. Chris Mullen gave 5 gift memberships. Bev D gave 5 gift memberships. Contrarian gave 5 gift memberships. Lily gave a gift membership. Sandra gave 20 gift memberships. And Master Bater gave 20 gift memberships. Well, thank you very much for all those gift memberships as well. W's for waterboarding. That's not bad. So I'm going to go to the gym real fast. And then I need to order stuff for tonight so I can do some baking and go from there. I is for interrogation. B is for black site. Yeah. Yeah. Do I Instacart? Typically, I do Instacart, yes. That was sort of my working plan. Instacart, yes. Through HEB. Heb. All right, I'm going to sign off for now. If you enjoyed the stream, like, comment, subscribe. I'm going to go to the gym and try to get my swole on a little bit. I've been Uncivil Law. Until later, my friends, I hope all's well. Cheers, my friends, and goodbye. I'll talk to you later, Brandon. I'm going to go to the gym first. I need the exercise. I need to clear my head, but we can talk later, okay? I'll talk to you guys later. Bye for now.